It has already hosted 3 international conferences, including of this one, and also focused workshops which have witnessed participation from all corners of the world. An edited volume on national space legislation is also due to be published shortly, and a flourished web blog dedicated towards cutting edge issues and developments in aviation and space laws is already in place. With the development of space technology witnessing an exceptional growth, and with the increasing involvement of private corporations in the funding of related research and applications, the days of private commercial space tourism have already been arrived with a flourish. The purpose for which such tours may be undertaken may range from recreation and leisure to business. Even the extent of the tour may differ, thus giving rise to subcategories of space tourism like orbital, suborbital, and lunar space tourism, to name a few. Given such a flurry of activities in this sector, one must carefully consider various legal implications and resulting concerns. Issues such as authorization, supervision, registration, certification of the crafts and crew used, and the liability resulting from these activities are also foremost importance and concern for us today, especially given their ties to the multiple existing and potential regulation on the domestic as well as international levels. This conference intends to map the current developments, domestic and international regulatory response, and the legal ramifications of the same in the backdrop of myriad developments taking place in this sector. The global of this development, taking into consideration, the conference aimed at to find out the true nature and extent of the various legal challenges that regulation of space tourism may face, and to explore possible solution to such challenges, as well as to review the various attempts being made or to be made to develop and nurture such solutions by the public and private stakeholders involved in space tourism. As the importance of space law and space tourism is being recognized by law schools and universities across the globe, conferences like this help like-minded people to come together and raise their views and opinions to a larger audience. Even like these seminars, conferences, workshops increases awareness among the students, undergraduate and postgraduate researcher about the air and space law, which help in bringing out quality research output in the form of collaborative research projects and publications. As head of this university, I welcome any such collaborative research proposal from anyone of the research person, any other universities, and we are happily welcome and to contribute, ready to contribute, even the part of the cost to undertake such research projects, collaborative research projects. So I welcome all such suggestions and proposals to the center to have add more inputs in the literature and legal field of space tourism and space laws. It is my privilege to welcome you again, and I hope the conference will be successful and the deliberations inputs will definitely come out with some publications by the center as well as the researchers and the resource person. Thank you all.
Thank you so much, sir, for that welcome address. Sandeep, sir, should we move on to your speech or should we yield the floor to Professor Jaku?
No, Professor Jaku can actually take over because actually
Sure.
it's late there in Canada. So
Definitely.
yeah,
Most definitely.
we'll follow.
So,
Right.
so just briefly introducing Professor Jaku, as everybody would already know about him. Professor Jaku is a professor at the Faculty of Law and also an acting director at the Institute of Air and Space Law at the McGill University in Montreal, Canada. Today, he will be speaking briefly on the topic on the rule of law and capacity building in space law. And without further ado, I would yield the floor to Professor Jaku for the purposes of the speech. Thank you, sir, for being here.
Well, good morning, good evening, good night, wherever you are. Sandeep, you are always very nice, very sweet man. You have a pity on me. If I look sleepy, that means I'm sleepy. So it's almost midnight here in Montreal, and I got up quite early this morning. I have a number of meetings, but then I have to teach for 3 hours. So, but again, if I miss something, please forgive me. And again, thank you very much. Rohit, very nice. Thank you very much for your nice introduction. And I will start. I feel very honored by your invitation to be a keynote speaker at this conference. First of all, I would like to congratulate Dr. Bhatt for you and the Center for Aviation and Space Laws for organizing this conference. I'm pleased to note that the organizers have invited so many distinguished and highly knowledgeable experts from various parts of the world, some of whom I know very well. I have known Martha, Melissa, and Dr. Sachdeva for several years. They are leading experts of space law, and I respect them profoundly. And I feel privileged to be in their company or company of other distinguished speakers. The theme of the conference, in my view, is quite important and timely. Just looking at the line of great line of speakers and topics in the program, specific legal and technical issues will be ably and adequately addressed by other speakers. So given the time constraints, I will keep my remarks general, basic, and high level. Since legal principles and rules for the regulation of space tourism have not yet been adequately adopted, I intend to state what ought to be done. My comments are limited to the necessary mechanism for the adoption of lex defrenda, or what the law should be. I will be using space tourism as a case study to underline the necessity of the rule of law for all space activities. And in addition, I plan to describe the need for an appropriate capacity building in the governance of outer space activities. The subject of space tourism currently appears to be fascinating, exciting, and most talked about among commercial enterprises, individuals who have billions of dollars, governments, and academics. However, in my humble opinion, this is, and certainly will be, just a segment of another industry, which I call space travel industry. And that means travel to space, from space, and via space. Space tourism is no more science fiction. Its technical viability was first proven in 2001 by Virgin Galactic. The achievements of Virgin Galactic and Blue Origin last July again demonstrate that not only is the technology here, there is an active race and great competition in this budding industry. Indeed, various types of vehicles are being developed and will eventually be used for space tourism. They include vertical takeoff, landing types of vehicles. They include vehicles that would operate horizontally in 2 stages or single stage to orbit. What various types of vehicles have in common is their ability to operate seamlessly in airspace and outer space, and their potential to provide suborbital, orbital, and even point-to-point services on Earth. I prefer to call such vehicles aerospace vehicles. I believe for several reasons, such aerospace vehicles will be the main transportation systems, not only for space tourism, but also for point-to-point travel to various destinations on planet Earth. Therefore, within next 15, 20, maximum 25 years, I see strong possibility of travel from New Delhi to Montreal in about 1 or 2 hours. The ticket price would be at the same level as an airline ticket today, if not lower than that. This is, of course, significantly lower than the current rate of about $250,000 for a trip to the edge of space for a few minutes in a suborbital flight. However, all these exciting advances, potentials to happen, there are major challenges. In my view, there are two most important prerequisites for smooth emergence as well as economic viability of space tourism as an industry. The first is the safety of aerospace vehicles. And the second is proper regulatory regime for space tourism. As with all other modes of transportation throughout history, it is obvious if such vehicles are not acceptably safe, people will not be inclined to be on board. These vehicles will not become accepted mode of travel, except, of course, for those few individuals who are looking for short-term thrills and willing to ignore high risks. The level of safety of aerospace vehicles will be primarily determined on the basis of technical standards and procedures for the design, construction, and operation of such vehicles, and their airworthiness and spaceworthiness certification. In addition, such standards and procedures must also be in place for ground facilities like airports, spaceports, for certification of pilots or astronauts, for radio communication, for navigation in airspace and outer space, etc. To be economically viable, space tourism must be perceived and designed essentially as a global industry. Therefore, such standards and procedures must be globally uniform and legally binding, both at national and international levels. To begin with, they may be adopted as best practices of one country, but they ought to be agreed upon by all countries and followed by all space travel service providers. As I mentioned earlier, the second prerequisite for economic viability and sustainability of space tourism is a proper and effective regulatory regime. Like the required safety standards, such a regulatory regime must be uniform and international in scope, and more importantly, legally binding in character. Again, as I mentioned earlier, space tourism ought to be a global industry. As we know, no state allows passage or transit through airspace without prior permission. Therefore, to make space tourism as a successful global industry, it is imperative to have an international treaty under which entry into foreign airspace could be granted. And in addition, the determination of legal status of space tourists, landings at foreign airports or spaceports, passports, visa requirements, health consideration, security risks, etc., all are international matters to be addressed and agreed upon at the global level. At the initial stage, space tourists might be deemed to be spaceflight participants under domestic law, as is the case in the United States. However, the space business to operate as a global industry and for space travel to be regularized and commercialized, such participants should be and would need to be legally considered as passengers, as is the case with commercial air travel today, which evolved quickly with the commercialization of air transportation. Space tourism service providers will be under duty of care and would be subject to liability for any damage, injury, or death. There's a close affinity between aviation and space transportation systems. And as I said earlier, aerospace vehicles would operate seamlessly in airspace and outer space. Consequently, they are subject to different legal regimes. International aviation law recognizes exclusive sovereignty over national airspace. On the other hand, space law allows freedom of exploration, navigation, and use of outer space. It's clear that space tourism will not be subject only to space law. In other words, space law would be inadequate to regulate all important aspects of space tourism. Such activities ought to be regulated heavily under aviation law too. I believe to make space tourism again as a successful global industry, it's imperative to have international treaty that establishes appropriate international organization. In fact, currently, there is no need for such a treaty, as we already have one, and that is the 1944 Chicago Convention. I believe that International Civil Aviation Organization, ICAO, established under the Chicago Convention, is the most appropriate international institution for the purpose of adopting and implementing uniform technical standards for aerospace vehicles, for spaceports, and all for the purposes of space tourism. Here I'm reminded of Jean Monnet, the post-war architect of European unity, who once wrote, "Nothing is possible without men." I will add without women also. So nothing is possible without men and women, but nothing is lasting without institution. So a simple treaty will not be good enough to make space tourism a viable industry. There has to be an institution. And that I said earlier, institution is already in place in the form of ICAO. I may mention in 2013, my colleagues and I published a book entitled The Need for an Integrated Regulatory Regime for Aviation and Space. Thanks primarily to the excellent work of ICAO today, undoubtedly, aviation is the safest mode of transportation. We recommended that ICAO should undertake initial steps, I'm saying the word initial steps, for the adoption of technical standards and governance principles for space transportation systems, for space travel, including space tourism. I believe that our recommendation has become even more valid today than what we thought about a decade ago. With a considerable increase in traffic in airspace caused by vehicles for space transportation, there will be significant risks to aviation safety. Therefore, it is in the interest of ICAO, I will say, in fact, in the interest of global aviation community, that transportation systems for space travel, including space tourism, must be regulated by one organization. This logic has been well recognized by the Federal Aviation Administration of the United States, as it regulates both aviation and space transportation systems. It may be noted that there would be no need to amend the 1944 Chicago Convention in order to extend IQ's mandate over transportation systems for space tourism. The IQ Council is authorized to modify annexes to Chicago Convention. The Council can and perhaps should modify the definition of aircraft as included in the annexes. The definition of aircraft is not included in Chicago Convention. It's only in the annexes, which and the Council is authorized to modify that definition. And that should be modified to include, saying aircraft includes aerospace vehicles. And there is a precedent for inclusion of new technologies and applications in existing airspace. For instance, under its Aeronautics Act, Canada changed the definition of an aircraft to include rockets. Now, I'm fully aware of the technical differences between aircraft and aerospace vehicles, as well as the differences in legal regimes that apply to airspace and outer space. But I believe such issues can and should be addressed in and or under or through an experienced international organization like IQ. Having underlined the importance of safety and uniform legal regime of this emerging mode of transportation, I would like to add a final thought that I think is important for policymakers, educators, students, and future generations. And this is a message even more important for civil society and academic institutions such as the Center of Aviation and Space Laws in Kolkata, that has its mandate to critically study new developments, opportunities, challenges humanity is faced with in aviation and space fields. In my opinion, legal regime governing all space activities, including space tourism, is a highly complex system. It's a system that involves advanced technologies and that has technical, military, security, social, political, economic consideration and impacts. Moreover, the governance of space activities involves serious and competing interests of various nations, commercial and industry stakeholders, and have tremendous impacts on the life of individuals. Such a regime cannot be a singular, siloed, or detached from other fields of law. Thus, it should comprise of concepts, principles, and rules derived from several different fields of law that apply to space activities, that applies to aviation activities, and other fields. In my view, the development of legal regime governing all space activities, including aerospace activities, and including space tourism, need to be undertaken by suitable legal professionals. And what does it mean, suitable legal professionals? They must be adequately and properly educated in aviation and space law and research. Therefore, when learning, teaching, researching about such a regime, it is imperative to take into consideration the application of various treaties, laws, both in the aviation side as well as space side, and also constitutional system, legislative and administrative processes. And events as this conference this evening, this night, or today, provides a perfect platform for scholars and practitioners to exchange experience and ideas for a better, safer, and common future for all. I thank you very much for your attention. I thank you again, Dr. Bhat, for inviting me to this conference. I wish I could stay longer and benefit from the presentation of other experts. But as you know, it is midnight here in Montreal, and I will be signing off shortly. I wish you all enjoyable and fruitful conference. Merci beaucoup. Thank you and good night.
Thank you so much, Professor. All right. Continuing on with the conference now. Thank you so much,
Thank you.
Professor Jaku, for your address. Indeed, it was extremely insightful, and I think lays perfect context for the entire conference that is going to go on ahead. I would now like to go back to
It was a
Professor
pleasure.
Sandeepa Bhat, who just briefly introducing Professor. Professor Sandeepa Bhat is a professor of law at the West Bengal University, National University of Juridical Sciences. And indeed, he is also the director for the Center of Aviation and Space Laws, who is organizing this conference. He has vast experience in terms of researching on five major research projects, including those associated with the World Bank, with the ISRO, the West Bengal Judicial Academy, Ministry of Judicial Justice, and Ministry of Environment, Forest, and Climate Change in India. He's also a member of the American Society of International Law, the International Institute of Space Law, and has also participated and written extensively and has had publications in terms of books, articles in the fields of air and space law both. I invite Professor Bhatt for his inaugural address so that we can continue on the conference. Professor, I yield the floor to you.
Thank you. Thank you, Robert. Honorable Vice Chancellor, distinguished resource persons, my friends and colleagues, a very good morning, good afternoon, as well as good evening to all of you. Last year has been quite fruitful with respect to our activities, and we could able to have 3 major international conferences. Of course, with all cooperation from my friends and colleagues, both within India as well as from abroad. I'm really grateful to them for their extended cooperation. For every program, whichever I am organizing, I'm getting actually good responses from my friends and colleagues. Of course, almost all of them are very busy academics, and I know that actually they will get a very little time. Despite that, actually they have accommodated my request, and I'm really thankful to all of them for this. Today, the theme of the conference, as Honorable Vice Chancellor Sir has already mentioned, it is on something which is currently happening, the space tourism. Of course, a decade back, I was basically saying that actually this is the fascination of the next generation whenever I'm teaching anything on space law or space tourism. But now I should say that this is the fascination of the current generation itself. So we saw the happening of actually the events in the last year, and it's also developing further. Now, in my this inaugural address, of course, some of the issues which I wanted to point out has already been addressed by Professor Ram Jaku in his keynote speech. But here, I'm not taking any stand or I'm not taking any position. Rather, I'm trying to flag off certain legal issues, whatever are there. And in all probability, the subsequent sessions, the speakers are going to actually address on each of these the issues. Now, the journey to the space tourism unfolded in April 2001 with Dennis Tito becoming the first space tourist, and subsequently the 6 other tourists going to the outer space and staying there in the International Space Station, so on and so forth. Of course, all these activities were primarily carried on by the state agencies. And in 2003, Space Adventures became the first private company to get involved in the space tourism activities. Though not independently, it basically collaborated with the Russian space agency, Roscosmos, and 2003, the space tourism activity was carried on. But after 2010, we find a break for the space tourism activities, especially because Russia was thinking in terms of developing technology, and there were actually plans for making the tourism more safe. So by virtue of that, a break was taken to carry on the space tourism activities. Maybe that this break from the governmental agency has provided a kind of a break to the private entities to join the race. We find that a lot of development has taken place from the private space players in the field, and they started developing technology for both orbital as well as the suborbital tourism. And the results we know, the last year, 2021, has been really fruitful in terms of actually the space tourism, Virgin Galactic, Blue Origin, and SpaceX, all three entering into the space tourism the activities and having a kind of a race amongst themselves for the purpose of catching this, maybe a lucrative business, I should say, right? So therefore, developments are going on with respect to this. Now, in this context, of course, I'm not an expert in the technical field. I'm not very sure how much of time would be required for having a larger business in terms of space tourism. I would like to flag off only the legal concerns. What are the major legal issues which are there with respect to the space tourism? First of all, the question of demarcation and applicable law. I always tell my students that aviation law and space law are the two different sets of law. I believe that there is nothing called air and space law. We have aviation law, we have space law. Air and space law together does not make much sense, especially because there is no correlationship between the aviation law and space law. Rather, there is a kind of a contradiction between aviation law and space law. We can find differences in terms of liability, maybe in terms of registration, state responsibility. With respect to all of them, we find that there are marked differences between aviation law and space law. And that is the very reason why I made sure that when we name our center, I named it as Center for Aviation and Space Laws. I'm using plural, right? Center for Aviation and Space Laws. It is not air and space law or aviation and space law, primarily because actually there is an inherent difference or contradiction between aviation law and space law. In light of that, first question is where exactly the airspace ends and where the outer space begins, because at the end of the day, we may have to apply aviation law or space law depending on the kind of activity. Especially in the space tourism activities, as Professor Ram Jaku has pointed out, vehicles which are used are the aerospace vehicles. They can move in the airspace with the help of aerodynamic elevation, just like an aircraft. They can also orbit around the Earth like a space object. They would come within the ambit of both aviation regime as well as the space regime. And what law is applicable with respect to actually different activities? Whatever may happen in the course of space tourism, that itself becomes debatable, and we need to fix it. Maybe Professor Ram Jaku was basically speaking about aviation law and ICAO being the administration. Yes, that is one of the proposals. I'm not going to take a stand on that, as I told earlier itself actually. Let me just flag off the issue. Because see, what I'm trying to point out here is that we have to have a fixed regime. Be it aviation law or space law, we have to have the fixed regime. Otherwise, there would be problems. We will always be under the dilemma with respect to whether we have to apply aviation law, space law, or maybe a hybrid law if at all required. Some scholars are arguing for a hybrid law for the space tourism. Right. So that's why in this context, as we know, Richard Branson and then Jeff Bezos' space tourism. Richard Branson only reached 86 kilometers above the Earth's surface. So the question is that whether he entered into the outer space or was he still in airspace? Going by NASA, which speaks about 50 miles, yes, he's in outer space. But most other, most other countries, or maybe most other scholars across the globe, believe that the outer space may start beyond the carbon line, beyond 100 kilometers. So in light of that, question is whether the Richard Branson's flight was a space flight or a space tourism flight, or is it just an aircraft? So that's why actually demarcation and applicable law becomes one of the most crucial aspects in the space tourism. Now, carrying forward from this question of demarcation or applicable law brings in multiple other issues as well. Like say, for example, registration. Should we register this aerospace vehicle under the space law, or should we register it under the aviation law? Because the process of registration is entirely different under both of them. Space law, we have the Registration Convention 1975 speaking about dual registration. National registration as well as international registration, and both of them have to be carried on by the launching state. The launching state has to register. But under the aviation law, it is actually the owner of an aircraft or owner of a particular company has to register the aircraft. So therefore, the registration process is entirely different. Who will register is different under the space law and aviation law. That's one thing. And another part of the problem comes up under the space law. Because under the space law, there is a requirement of 2 registration after the launch. If we look into Article 2 of the Registration Convention, it says that soon after the launch, the launching state has to register the space object. Then it has to disseminate certain information to the UN Secretary General, who would be registering them in the international registry. But in space tourism, wherein these tourist objects would be entering into the outer space for a short span of time, how much of time would be available for such registration? Some of them maybe say 5 minutes flight, 10 minutes flight, or maybe even half a day at the maximum, something like that actually. In those circumstances, where is the time for this double registration to be complied with under the Registration Convention? And interestingly, it is not a one-time registration for every launch. Under the aviation law, yes, the owner of the aircraft might go for one-time registration and he can have frequent flying. That is possible. But not under space law, because under space law, Article 2 says after each launch, the launching state has to register the space object. That is the problem with respect to the registration. Then, under space law, Article 6 clearly says that there is a requirement of authorization and continued supervision of every private space activity. It's very significant because state would attract the responsibility for its failure, any failure. It has to regulate the private space activities. Certification and continued supervision. If we look carefully into Article 6, it casts this responsibility on the appropriate state party. There is a singular which has been used. It doesn't say appropriate state parties to certify and continuously supervise the space activities. Now the question is, which is this appropriate state party? Is this the state to which the operator of the space tourism belongs? Is this the state to which the person who is sponsoring the space tourism belongs? Right? There may be a wealthy businessman who might be sponsoring the entire tourism, this particular, the mission. Is it that country appropriate state party? Or is it the country to which the different tourists belong? Tourists might come from 4 different countries or 5 different countries. Which country is the appropriate state party under Article 6 for the purpose of authorization and continued supervision itself is in limbo. That is another significant problem. Then, status of the space tourists during the emergency. We have the Outer Space Treaty, we have the Rescue Agreement. The Outer Space Treaty 1967 says that astronauts are envoys of the mankind. They're the representatives of the whole mankind. They're doing some common good. Therefore, some emergency assistance has to be granted. Similar provision we can find under the Rescue Agreement with respect to personnel. Astronauts as well as personnel, that is extended. However, if we look carefully into the Outer Space Treaty and the Rescue Agreement, and especially the Rescue Agreement, we don't find any provision with respect to the cost reimbursement for the emergency assistance. With respect to space objects, yes, there is a cost reimbursement. Article 5 of the Rescue Agreement basically speaks about actually the cost reimbursement. But if it is a personnel or if it is an astronaut, any state which is rescuing and then incurring the cost in terms of the rescue and the return, it is not entitled to get back the cost. In simple terms, logic of this provision seems to emanate from astronauts as envoys of the mankind. They are the representatives of the whole mankind because they are doing some common good in outer space. That's what the logic. But whereas the space tourists are concerned, they are not going to the outer space for any common good. They are going for personal enjoyment. And can we impose an absolute obligation on a third state to rescue them and return them to the launching authority even without getting back any cost? That itself becomes a kind of a debatable issue with respect to the status of the space tourist during emergency. Next significant question crops up with respect to the protection of space environment. Whenever the tourism activities start, there would definitely be damage caused to the environment. Not just in terms of human waste, whatever may be thrown therein, or possibility of actually such kind of other things, but also in terms of the emission of the fuel during these launches. Emissions, a lot of emissions which might take place. So what should be the liability for environmental damage? If we look into the Outer Space Treaty or Liability Convention, they're all anthropocentric and they don't mention about damage to the outer space environment per se. Except Article 9 of the Outer Space Treaty, which basically speaks about prevention of harmful contamination of outer space. Harmful contamination, which is a very narrow term. It's a very narrow term. Only when the contamination is harmful, that is prohibited under Article 9 of the Outer Space Treaty. Otherwise, the normal contamination or normal damage to the environment is not covered within the ambit of Article 9. That is why we need a stricter regime with respect to protection of environment. And more importantly, critics have come up with the argument that space tourism is not a sustainable activity. It's going to add on to the emissions. It is going to actually cause more and more damage, not just to the outer space environment, but also to the Earth's environment. Next, in terms of crimes and torts, there would also be problems. What if a tourist commits a crime or a tort against another tourist in the course of a space tourism? How do we decide this? Who will be having jurisdiction? Whose law should be applicable? Should it be the country to which the offender belongs? Should it be the country to which the victim belongs? Should it be the country wherein the space object has been registered? Right? So which is that country that exercising the jurisdiction and whose law is applicable with respect to the crimes and torts itself becomes debatable. Next, about the liability for damage or injury caused to the space tourist. Suppose if in the course of the journey, some kind of an injury has been caused to the tourist, or his personal belonging has been damaged during the course of the journey. Are we going to apply aviation law or the space law? If we apply the aviation law, it would be maybe the Warsaw Instrument or the Montreal Convention. Warsaw Convention system or the Montreal Convention, which would fix the liability on the carrier. Carrier is liable to pay the compensation to those people who are part of actually the journey. But on the contrary, if we look into the space law, there is no mention about private person's liability. Space law speaks only about the liability of launching state or launching states. It's only the state liability. So again, it's a crucial factor which law we are going to apply in terms of fixation of liability to the damage caused to the passengers. Finally, one interesting thing I found in the US legislation, US norms. United States has actually allowed space tourism. Of course, US policy has been to go for more and more commercialization of the space activities and not to have obstacles to that. So that has been a policy over the period of time. If we look into the US position, it speaks about allowing the space tourism subject to an informed consent of the tourist. Because under Article 6 of the Outer Space Treaty, licensing as well as authorization has to be given by the respective state. So if US is authorizing, it is saying that the operator has to take an informed consent from the tourist that the state, while authorizing under Article 6, is not certifying that the launch and the return is safe. Or in other words, US is trying to shred away its responsibility under Article 6 by saying that we are not responsible if at all there is any disaster which happens in the course of the tourism activities. We will not take any responsibility for the life or the health of the tourists. This is what actually they are doing out of the informed consent. My question is, can this be done by a welfare state? We are not speaking about a situation of a laissez-faire. Now we are having a welfare state wherein the state has to take care of all these kind of issues. And can it shred away its responsibility, that too under an international treaty, by saying that we are authorizing right? We are actually licensing the activity under Article 6, but we are not responsible for any kind of a damage, whatever might occur out of this. I don't think actually it's a kind of a justifiable approach. So finally, let me wind up by saying that, of course, I'm not completely against the space tourism as such. Technological developments would be something maybe required. But at the same point of time, we need to look into these legal concerns. And more particularly, which I have not addressed, is the concern of sustainability. Is it sustainable or not? And I'm sure that there will be multiple other presentations, especially Professor Dave Webb is going to actually present on this particular issue itself. And I'm looking forward for his presentation. So let me just actually wind up here, and let me thank actually all the resource persons as well as participants whoever have actually joined this session and joined today. And I'm very sure that by the end of the day, all of us would be enriched with vast knowledge of all resource persons as well as the paper presenters. Thank you so much. Once again, let me welcome all of you to this particular one-day discourse.
Thank you so much, sir. I think that brings us extreme insight into the legal concerns with space tourism, which is something that everyone is looking forward to. I'll directly now move on to Professor Gagnon, who shall be talking about the topic, the dangers of privatization of space. Now, Professor Gagnon was a founding member of the Global Network Against Weapons and Nuclear Powers in Space when it was created in 1992. He has also served as the coordinator of the organization since its origin. And he began working on space issues in 1982 during the Ronald Reagan administration, and is a Vietnam War veteran of the US Air Force. And he began his career as a professional organizer with the United Farm Workers Union in Florida, organizing fruit pickers. He lives in Bath, Maine, and he was also with us during our workshop on the peaceful uses of outer space that was conducted previously. We welcome Professor Bruce Gagnon again, and I'll yield the floor to you, sir, for your thoughts and comments.
Professor, you are on mute. Please unmute yourself.
Yes.
Yes, thank you. Thank you very much. About my PowerPoint, I don't know how to, I've never used this system before. I don't know how to put it up. Could you tell me?
So right beside the hand emoji would be an arrow pointing upwards that allows you to present your screen. So if you could click on that, it'll give you three options: presenting a window, your entire screen. You could choose maybe a window and say present the PowerPoint presentation in particular.
Okay.
If that doesn't show up, you could just present your entire screen and then open the presentation on your screen, and we would be able to see that.
Can you see it?
You can also share.
Able to see.
We also have, yeah, I think your presentation is
We're
done.
able to see it, sir.
You can see it?
Yes, sir.
Okay. Well, let me, before I start, let me say thank you very much to Dr. Bhat for inviting me again. I think this is a very, very important conference because few in the world are talking about or even thinking about the future of space law and liabilities from national or private impacts. And you really just addressed some of that when you were talking about space tourism. So I thank you again, and I'm really happy to be connected with all of you. I'm going to be talking about the privatization of space, but first I want to give a little history. The U.S. Space Command published a document in 1997, and right here you might see my cursor in this paragraph, the last sentence. I want to read it to you. It says, likewise, space forces will emerge to protect military and commercial national interests and investments in the space medium due to their increasing importance. So this document is all about US controlling space, dominating space, and denying other countries access to space. And they very importantly say that part of their mission as a military organization will be to protect U.S. Commercial interests and investments in space. So I think that's very important to hang on to. The U.S. space program was largely founded by the German scientists, rocket scientists, that worked for Adolf Hitler during World War II. They were building the V1 and V2 rocket. Major General Walter Dornberger in the top left was the liaison from the military, working with rocket scientists like Wernher von Braun, who he's sharing this piece of paper with. And after the war was over, World War II was over, von Braun and his rocket team, along with Major General Walter Dornberger, came to the US to create the US space program. They had been running an operation, the bottom left picture, inside a mountain tunnel where they were using Jews and gypsies and French resistance fighters as slaves, building these rockets. So again, they came to the United States. They brought over 100 of these rocket scientists, and they eventually moved to the state of Alabama to create the US space program. And it was there that they began offering a vision for the future of colonizing space. And you see this middle picture on the bottom, the conquest of space. And so again, this idea of domination, control, is very much present in this early time of the creation of the US space program. And in fact, they even call themselves the master of space. This is at the Space Command headquarters building in the state of Colorado in the United States. So it's, to me, a very dangerous kind of ideology that is being introduced as we begin to talk about colonizing space and privatizing space. I'm sure you all know about the Outer Space Treaty of 1967 that said space planetary bodies would be the province of all humankind, that no country, no individual, no corporation could claim ownership of any of the planetary bodies. And this was the United States signing the Outer Space Treaty along with the United Kingdom and the then Soviet Union. More recently, there's been an effort by China and Russia to create a new treaty that expanded on the Outer Space Treaty and to try to prevent an arms race in outer space. But the United States and Israel have been blocking this treaty for more than 20 years. Presently, I think one of the biggest issues we face when we look at space and space law is this idea of mining the sky. This book is by a NASA scientist. And very recently, during the Obama administration in Washington, President Obama signed a law giving American corporations the right to go out and make land claims on various planetary bodies. And this is really breaking out of the Outer Space Treaty, breaking out of the Moon Treaty that again said that nobody could make these kind of legal claims of various planetary bodies. So this is an aggressive step forward by the United States to try to introduce essentially capitalism in space. And then today we see these two very rich men. On the left, Jeff Bezos, he owns Amazon, he owns the Washington Post. On the right, we have Elon Musk, the owner of Tesla and SpaceX. Well, Musk is saying that he wants to go and colonize Mars. He wants to occupy Mars. And he also says he wants to nuke Mars. He wants to use 10,000 nuclear weapons, blowing them up in the atmosphere of Mars in order to terraform Mars, to make it green like the planet Earth, so that civilization can move there. He's not asking for anyone's permission. Imagine the danger of launching from the Earth thousands of nuclear devices on rockets that blow up from time to time. It's all screaming for regulation, but right now there is none. It's like the Wild West here in America, with the cowboys going out and taking control of the Wild West and making their own rules as they went along. I think it's extremely dangerous. At the same time, the nuclear industry views space as a new market, and they're now talking about creating a nuclear rocket in order to get to Mars in half the time that you would get there with a conventional rocket. And they are now planning to test these reactors just above our heads in lower Earth orbit. When asked, well, why can't you test these nuclear rockets on Earth before you try to use them in space? And they say because there's too many environmental regulations in the United States. And so if they go into space and test them, they would have no regulations, no laws, no rules. But what happens when you launch nuclear devices just over our heads in lower Earth orbit, and they fail and they fall back to Earth? They burn up on reentry and spread plutonium or uranium globally. This has happened before, both by the United States and the former Soviet Union. There have been very bad accidents over the years. On our website, spaceforpeace.org, we have information about those previous accidents. From the very earliest years, the United States was very excited about moving nuclear power into space. On the left is one of the first nuclear reactors that was designed by the United States. It was massive. Fortunately, it was never used. And on the right, you see a picture of one of the first military satellites that had plutonium on board. And in fact, it was one of these early varieties of satellites, like is pictured there on the right, that fell back to Earth in the early 1960s, burned up on reentry, and spread 2 pounds of deadly plutonium-238 that disintegrated and was spread as dust across the Earth. Dr. John Goffman, one of the early founders of uranium in the United States, studied that particular accident and believes it's one of the reasons for increased cancers around the Earth today. So there are consequences to these unrestricted efforts to put nuclear power into space. The other thing that I'm very concerned about is the moon race. India, I know, is very interested and excited about going to the moon. United States and China are both rushing there now, and people are predicting that there's going to be a very even deadly arms race to get to the moon and try to colonize or even control it. Now, some years ago in this book, Military Space Forces, the Next 50 Years, this was a United States congressional study. They talk in this book about the Earth-Moon gravity well. And they say whoever controls the L4 and L5 quadrants on either side of the moon will be able to control who can get on and off the planet Earth. Think of it like a well underground where people are drawing water from. If you're at the top of the well, you can control who gets in and out of the well. Let's say someone is at the bottom of the well. Maybe they fell down there or something like that. The person at the top of the well, because of gravity, basically, can control access. And so it's the same way with the L4 and L5 positions and military bases on the moon. One would be able to control the gravity well on and off the planet Earth. And in this study, On the right side here, at the very last sentence, you'll see marked in yellow, armed forces might lay in wait at that location and hijack rival shipments upon return. So already Congress is thinking about space piracy in the years ahead. Again, screaming out for law, screaming out for regulations and rules that don't exist today. Another area that's becoming profoundly in need of regulation is this massive launching of many satellites by people like Jeff Bezos and Elon Musk and others in order to launch 5G satellites orbiting the Earth and also military satellites orbiting the Earth. And the parking lot surrounding the Earth, the orbits around the Earth, are becoming dangerously crowded. And scientists are increasingly worried that there are going to be collisions in space. And when those collisions happen, they will create a cascading effect where one thing smashes into the other, it creates more space debris, and then that then creates even more collisions. And before long, space becomes a minefield or a piranha-laced river that you can't dare walk in because the piranha fish would eat you alive. In 1989, I organized a protest at the US Space Center, Kennedy Space Center in Florida. And our speaker that day was one of the early Apollo astronauts. His name was Edgar Mitchell. He was the only astronaut ever to speak publicly against the arms race in space. And he said, if we have a war in space, it will be the one and the only that we ever have, because we will create so much space debris that we will not be able to get a rocket off the planet Earth. We'll be entombed to the planet. So now as we're in this danger zone where it's getting crowded and dangerous up there, again, we're screaming out, asking for regulation. Astronomers are concerned because they're losing the night sky because of all the blinking satellites up there. They're increasingly organizing and speaking out. And then finally, because of all the pollution created by these thousands of satellite launches that are expected in the years ahead to put up there like 80,000 mini satellites, the ozone layer above the Earth is becoming destroyed. And as that happens, our already bad climate crisis will get worse. Climate crisis will grow worse because of all these launches by private people, by various countries. Again, no regulation, no thought about what we're doing to the Earth environment by all of these launches. So finally, just one more picture about the junk. 1950, virtually nothing in space. And today, massive, massive problem of space debris and no regulations whatsoever. This drawing was done by a dear friend of mine many years ago. I don't know if you can read the bottom. It says, "It's looking good, but let's play down God." In other words, reduce God. He's not very important. And get more size on the corporate sponsors. This is what we face today, my friends, as you well know. I thank you all again for inviting me. I thank you for your really important work. And good luck to everybody.
Thank you so much, sir, for that what I would call bleak, but also a very big reality check on the current status of the world right now. All right, welcome back, everyone. for the first technical session. In this technical session, we have various speakers talking about the specific aspects of how space tourism would now function and the concerns that are still prevalent as the industry is growing. For the first presentation, we have Professor Dr. Melissa Diswart, who shall be presenting on the topic of the effect of space tourism and the concept of astronaut under international law. Now, Professor Zwart is a professor of digital technology, security, and governance at the Jeff Bleich Center for the United States Alliance in Digital Technology, Security, and Governance. She is a thought leader in the area of law and technology and has a strong international profile in the fields of internet law and the regulation of access to and uses of outer space. She previously served as the Dean of the Adelaide Law School at the University of Adelaide and chair of the Council of Australian Law Deans. She is currently the Deputy Chair of the Space Industry Association of Australia, board member and fellow of the Australian Academy of Law, and a lieutenant in the Royal Australian Navy. We welcome Professor Melissa for her thoughts and comments on the specific issue on the concept of astronaut and the effect of space tourism that is prevalent today. Professor, over to you.
Thank you, Rohit, for that very kind and very thorough introduction. Thank you so very much. And thank you to Dr. Bhat for the invitation to present today and to the Centre for Aviation and Space Law for inviting me. I'm very grateful to be here. And I would like to acknowledge that I'm speaking to you from the land of the Kaurna people, the traditional owners of the land of the Adelaide Plains, and I pay my respects to their elders past, present and emerging, and acknowledge that space has been important to them from time immemorial. So thank you very much. Today I'm going to be talking about the effect of space tourism on the concept of astronaut under international law, and I think conversely, the effect of what it means to be an astronaut on space tourism. So I'm going to unpack that issue. Is there something very special about astronauts? So this paper will look at this time of the changing nature of providers and participants in spaceflight, and it will consider a variety of legal issues that arise from these developments. So specifically, I'll be looking at the concept of what is an astronaut, and then briefly touching upon the potential for future developments regarding licensing of crew and craft. So we know that from the early days of spaceflight, it was especially and exceptionally dangerous, and the early pilots were chosen from in the US Air Force and military test pilots, and the same in the USSR at that time. There's some great stories that are told about the original Mercury 7 astronauts, and particularly the fact that they were horrified to discover that the capsule didn't even have a window. So here they were, very brave pilots, very used to having control over their the object that they were flying, not even having a window and having even less control. So the issue of both the window and the issue of control is important, even to our consideration today of the role of astronauts and space tourists. And I also want to talk about how important it is to have a window, because we have come to learn the power of the overview effect and the profound effect that it has upon humans who have had the opportunity to go into space and to look back on Earth is something that we also need to acknowledge as being incredibly important, and I'll come back to that later. So what does it mean to be an astronaut now in the time of the successful, and I'm going to call them still really test flights by the space billionaires in 20 and 21? And in his sort of foundational work on space tourism, Tronchetti notes that space tourism at that point in time was more about the flight than the destination. And certainly the activities of the space billionaires in 2021 made that very clear. And we've already spoken today about how far into space they actually got. And we'll leave aside the 100-kilometre limit and the Kármán line for another day. But the question is that they made it either into or nearly into space. But now when we're talking about space tourism, we're talking about tourists going into low Earth orbit. We're talking about tourists going to the International Space Station. We're potentially talking about tourists going to the moon. And we're also, and this was touched upon by Professor Jaku as well, talking about commercial orbital or suborbital point-to-point flights, which are probably less about tourists and more about, in fact, passengers in the same way that we understand from commercial spaceflight. So even now, when we're talking about space tourism, it's important to understand that we are encountering new issues. So I'm going to consider if whether the term astronaut continues to mean something in this domain, consider the legal issues and whether there's a need for new legal regime to apply to these new spaceflight participants. So certainly, as we know, astronauts were given a special status for their training, their bravery, the risk they took. But we now have to consider if space tourists are deserving of this status. But conversely, and this is the other part of my question, as if they require greater and perhaps different legal protection. So that's why I also want to consider the issue of licensing. And it's important to note that at this time, the FAA has a moratorium which actually prohibits the issuing of regulations to protect the health and safety of crew and spaceflight participants until October 2023. So space tourism is regarded as a nascent industry and something that is deserving of a higher level of protection. So firstly, who is an astronaut? Under the Outer Space Treaty, Article 5, it tells us, and we've already visited this a couple of times today, so I won't dwell on it for too long, that astronauts shall be regarded as the envoys of humankind. And it requires us to render to them all possible assistance in the event of accident, distress, emergency landing in the territory of another state or on the high seas. And when astronauts make such a landing, they shall be safely and promptly returned to the state of registry of their space vehicle. It requires that in carrying on activities in outer space and on celestial bodies, the astronauts of one state shall render all possible assistance to the astronauts of other states' parties. And this article is an expansion of paragraph 9 of the UN General Assembly Resolution of 1962, the Declaration of the Legal Principles governing the activities of states in the exploration and use of outer space. So forms part of the very fundamental and, in fact, potentially the customary law of international space law. So the key obligations it applies are the astronauts are the envoys of humankind. Now, many pages of legal journal articles have been written about what this actually means and what the content of this obligation is. But I think it does relate to them having a very special relationship to the Earth, and I'm going to come back to this. It requires states parties to render assistance to astronauts in the time of accident, distress, or emergency landing on territory of another state's party or the high seas. As I've already said, it requires astronauts to render assistance to one another wherever possible. And it also requires states to notify of any phenomenon that may constitute a danger to the life or health of astronauts. So Article 8 of the Outer Space Treaty simply refers to personnel of a space object. And does this suggest that there may in fact be a difference? It does provide an indication that there should be an enhanced status given to astronauts. Moving on to the agreement on the rescue of astronauts, the return of astronauts, and the return of objects launched into outer space, it uses the terminology personnel of a spacecraft. Article 1 deals with the notification of accidents, distress, emergency, or unintended landing. Article 2 refers to rescue and assistance when under the jurisdiction of a state's party. Article 3, again, refers to rescue and assistance when not under the jurisdiction of a state party. And Article 4 refers to the state and prompt return to a launching authority. Now, the requirement to render assistance only arises where there is landing in the jurisdiction of a state party or a place not under the jurisdiction of any state. So it doesn't really expand very far the obligations under the Outer Space Treaty. Turning to the Moon Agreement, and I always have to pause here and say that Australia is one of the very few nations that is in fact a party to the Moon Agreement. Article 10 tells us that states parties shall adopt all practical measures to safeguard the life and health of persons on the moon. And for this purpose, they must regard any person on the moon as an astronaut within the meaning of Article 5 of the Outer Space Treaty and as part of the personnel of a spacecraft within the meaning of the Rescue and Return Agreement. So interestingly, the Moon Agreement also intends to extend even to people in orbit around the Moon and other celestial bodies the obligations arising under the Outer Space Treaty and the Rescue and Return Agreement. However, of course, I also need to say that the small acceptance rate of the Moon Agreement indicates that this attempted exception would most likely not be accepted by most nation states. So looking then, we've looked at space law, we've paused and looked a little bit at what might be the customary international law. What about state practice? We don't have a lot of this at the moment, although it is starting to emerge. One program that may provide us with evidence of state practice is, of course, the Artemis Accords, which deals specifically with emergency assistance to be given to, and it describes them as personnel in outer space who are in distress. And clearly, of course, this would encompass civilian and commercial operators, but it doesn't, again, address, and would be unlikely because of the nature of the Artemis program itself, encompass tourists. So, how do you qualify to be an astronaut, and how might this differ, for example, from being a space tourist? Clearly, with astronauts, there's competitive selection and extensive training. But there have also been notable exceptions to this, such as Christina McAuliffe, who sadly, as we pause to say, perished now 36 years ago in the Challenger disaster, who was a school teacher. And while she went through some very rigorous training at NASA, it was not the equivalent of being an astronaut. Recently, we had a Russian film crew going to the ISS with the actress Yulia Pereslid and her producer, Klim Shipenko, who landed with the cosmonaut Oleg Novitsky of the Russian Federal Space Corporation, Roscosmos, on October the 17th, 2021. Space shuttles provided the opportunity for various roles beyond the pilot or the operator. So you had the development of roles such as payload operator, and we've witnessed a variety of expertise go to the ISS. So further, space tourism operators then add another layer to this growth of the types of people who are now going into space, who sit on the cusp of what we might say, are they an astronaut or are they not an astronaut? Now, again, last year with the participants in the tourism space flights of the space billionaires, it was well known that those participants had very little engagement with the actual operation of the spacecraft. Because of the developments in space technology, these craft are largely autonomous. So their role in terms of engaging with the operation of the space object is very limited. Now, the traditional symbol of being an astronaut, or for something that might define someone also as being an astronaut, is the astronaut wings. And notably, in December of 2021, the Federal Aviation Administration of the US decided that with the advent of the commercial space tourism era, that it will now recognise individuals who reach space on its website rather than through the issuing of commercial space astronaut wings. Any individual who is on an FAA licensed or permitted launch and reaches 50 miles above the surface of the Earth will be listed on a website rather than being given wings. It notes that the Astronaut Wings program had been created in 2004 to really encourage people to engage in the exciting endeavour of spaceflight. And so it regards that this program has now been successful. But before the program ends, it agreed that it would award commercial space astronaut wings to those who had qualified for space travel in 2021, including 15 individuals who travelled beyond the 50 statutory miles above the Earth. So you will find that Bezos, Branson, and of course, most importantly, William Shatner, are all now listed on the FAA site and made their wings before the cutoff. The requirements, obviously, for NASA and the US military, and I'm only using these as examples, are different too. NASA issues silver pins for those who have completed astronaut training, and gold for those who have successfully flown in space. The US military has various requirements according to the service, issues wings to those who have completed the training, and for the Navy, Air Force and Marines who've flown above 50 miles or orbited the Earth for the Army. As I say, Bezos and Branson, in fact, had their own astronauts designed and made by their own companies prior to flight. So what then is the future for the concept of the astronaut in the context of space tourism? As I've said, the regulations themselves are changing. This is an area in the state of flux. You've seen the FAA trying to manage this in a time of transition. But I think it might be important to say that the overview effect and the importance of encouraging those who travel to space, particularly tourists, to use that opportunity to look down on Earth and to reflect upon the importance of environmentalism and to understand the link between space and the environment on Earth is really important. So whilst we may say that space tourism is a frolic of the ultra rich, that it is really, you know, harmful and damaging, I think that perhaps one of the benefits of space tourism is that it can manifest in the space tourist a recognition of ensuring that this experience might resonate with the concept of the astronaut as bringing unique understandings back to Earth. Moving very briefly then to the future developments and the need for regulation. It's interesting to note that as early as June 2019, NASA issued a directive to allow private astronauts to make short duration visits to the ISS to undertake commercial or marketing activities. And as we know, SpaceX has recently entered into agreements with Axiom to carry private astronauts to the International Space Station. Very recently, the UK-based company Space Entertainment Enterprise has contracted Axiom to build a content and environment module for the ISS called the C1, and it is scheduled for launch in 2024. It's important to note that C1 is affiliated with the actor Tom Cruise, who was scheduled to fly to the ISS in 2021, but was effectively gazumped by the Russian mission of taking the actress to the ISS. Commercial missions to the moon obviously are designed to follow very shortly thereafter. SpaceX has announced a plan to fly a space tourist on a flight around the moon as early as 2023. And as I've said, we're also looking at orbital and suborbital point-to-point flights, and the Chinese space plane company has just announced that it will be undertaking suborbital tourism and point-to-point travel by 2025. And that's the Chinese company Space Transportation, which is developing something called a rocket with wings. Hurrah, perhaps the return of the space shuttle for space tourism and point-to-point travel. That will enable low-cost deposit of satellites in low Earth orbit and will be faster for global travel than traditional aircraft. So what liabilities could and should apply to these activities? As I've said, there's a moratorium on these activities and introducing regulation, and it's certainly not something that is undertaken on commercial terms. Essentially, there's a system of waivers. There's no requirement that the vessel be essentially licensed as being safe to carry human beings. But if you are going to be moving to suborbital or orbital point-to-point transport, you would be looking much more at aviation style regulation, because as a passenger, you would be expecting the usual safety precautions. So just drawing these thoughts to a conclusion, what can we learn from the concept of astronaut and the experience of space tourism? Will we have to change our understanding of what it means to be an astronaut as we shift from the very few to potentially the very many? And as we shift from astronaut meaning someone who goes into space and undertakes engagement with activities, very dangerous and very novel activities, to someone who will be a passenger on a suborbital point-to-point flight. I think we will have to change that concept, but I think it is very worth considering the factors that make someone an astronaut and why we have created this concept of an astronaut and the sacrifices that have been made by astronauts. And I mean, when I use the word astronaut, I'm encompassing in all the different languages that have a similar word for astronaut, the sacrifices that these people have made, and learn from their commitment their training, their dedication and sacrifice, and understand what they have brought to us in terms of developments for the human race, and the great benefits that they have brought for us scientifically. And maybe we need to move on to now developing other concepts for people who are working in space, particularly as near Earth becomes a far more familiar domain within which we can operate. Thank you for your attention, and I very much have enjoyed talking to you today.
Thank you so much, Professor. I think that was extremely insightful on one of the most preliminary issues on this entire aspect, and it was very comprehensive to hear about how the concept of astronaut is interpreted, how it should be interpreted, etc. I will now yield the floor to Dr. Jennifer Brost, who shall speak upon the legal strategies to preserve the natural and cultural heritage of space. Now, Dr. Brost is an associate professor at the Southern Illinois University School of Law, cross-appointed in the SIU School of Medicine Department of Medical Humanities. She teaches courses on health law, criminal law, property, evidence, and professional ethics, and her interdisciplinary scholarship focuses on social structures and autonomy in an age of technology, such as human well-being within the American criminal justice system, public health systems, and space travel in particular. Professor Brost received her BA in Archaeology and Social Anthropology from the University of Cape Town in South Africa, a JD from University of San Diego School of Law, and her LLM by thesis on International Comparative Law from the Victoria University at Wellington, New Zealand. Professor Brost, I will now yield the floor to you to speak about the legal strategies to preserve the natural and cultural heritage of space, something that I believe the readers, the viewers will definitely benefit from in the larger context of space tourism.
Thank you so much. I'm going to pull up my screen here. Can you see that all right?
Yes, Professor, we can.
Thank you very much. And thank you so much to the faculty and students of the Center for Aviation and Space Laws, and a special thank you to Dr. Bhat for this opportunity to present. I've been looking forward to it for some time. And I do think perhaps in my background in the United States, when you get a law degree, it's a graduate degree. So you have to receive an undergraduate degree. And mine was in archaeology, and that certainly inspired my topic today and my interest in this subject. It hasn't been discussed, I think, as much because perhaps some might think it's premature to discuss having the conservation of cultural heritage in space. But I think it's just the perfect time. And we are going to be needing legal protections of heritage in space before in essence, we cause problems. And we can do that because we already have a framework for that on Earth. And we already have international agreements and understandings and experience on how positive that can be. And I would note that the images on my PowerPoint were all drawn from UNESCO World Heritage sites from all over the world. So hopefully they will probably speak louder than I do on why this is important. Space parks obviously have already captured our imagination for a long time, from the tiniest parks to major attractions on Earth. They are also something that our National Park Service, for example, in the United States, has worked with NASA to take advantage of looking back on our gorgeous planet. We have images from, our first space travel back on Earth, which were breathtaking, to now having images of major parks or segments of natural beauty on the planet, not just for environmental preservation, but also just for appreciation. But let's turn the camera for a moment outwards, because that first image I showed you in New Mexico was from a dark sky park, and points on Earth where we have preserved our ability to see what early humans could see when we looked up at night, and to see really the the glory of celestial bodies. And that's certainly part of the inspiration for space tourism in the first place. So we need an understanding of the legal framework here. And under UNESCO, the UN's Educational, Scientific, and Cultural Organization, we draw from the 1975 World Heritage Convention, which is ratified by nearly 200 countries. And soon after the convention, some operational guidelines were put forth, which stated the cultural and natural heritage are for each nation and the international community amongst their most important and priceless possessions. And that last word, possessions, always catches my breath because, of course, they're talking about possessory interests with respect to what they say the international community enjoys together. And that aspect of property law in space and ownership and sovereignty also impacts how we view our cultural and natural heritage. I would say that it's my opinion that the UNESCO framework has been a success. And as of July last year, there were over 1,000 World Heritage sites. 897 of them were cultural, more than the 218 that were natural and the 39 that were both, amongst the vast majority of the countries that had ratified this. Now, in order to be designated a World Heritage Site, and you need to be thinking, we're discussing space, how would you designate if this framework were applied in outer space, on the moon, on Mars, in space itself? Well, we have nominations, and just out of interest, our first heritage site was L'Anse aux Meadows National Historic Park in Newfoundland and Labrador in Canada in the 1970s. This is the picture of it. It's an 11th century Viking settlement, the first known European presence in the New World. And again, that caught my attention because, of course, it's a site of conquest. And we just heard Dr. Spurt mention how the importance to all peoples of these important sites of history and appreciation. And UNESCO needs to be cognizant of that, of course. And we have some more recent agreements expressing a need to be more inclusive globally on what we consider worth preserving. So only state parties to the World Heritage Convention may nominate a site, which of course would be of interest to who could nominate a site in space and how you would limit that. So nomination is reviewed by 3 intergovernmental bodies, which inform our UN World Heritage Committee. So it's already, again, very much an act of cooperation and collaboration. And Italy happens to have the most World Heritage sites at the moment, but there are many that are staggeringly beautiful. So, of course, when we're talking about cultural heritage as opposed to natural heritage, we're talking about sites that are earthbound because that's where people are. And there are not so many people in space yet, but there could be. So I would imagine that most of the framework would apply to natural heritage out in space initially, but not necessarily. So I would also mention that cultural heritage can include astronomical heritage, and it's only of recent interest that organizations such as ICOMOS, the International Council on Monuments and Sites, now has a new focus on astronomy and archaeoastronomy. So if you're thinking about Stonehenge, for example, these heritage sites in which early peoples were monitoring and interpreting the skies, or the Aztec pyramids of the sun and the moon, we now have special attention to that with an understanding of the science behind it. So for the criteria to be inscribed as a World Heritage Site, and if we could apply this to space as the framework already exists, we have some operational guidelines. So as of July 2021, It's still that the site must be deemed of outstanding universal value, which means so exceptional as to transcend national boundaries and to be of common importance for present and future generations of all humanity. And to me, that strikes me immediately that this could apply to space. It has 10 criteria as listed in the convention, and I've just selected a few here that I think might work. One is to represent a masterpiece of creative genius. Who knows what arts and just works of creation we might create with respect to our travel and space travel and tourism. Another is exhibit an important interchange of values, including technology and design. And some preserved cultural heritage sites actually are quite urban or industrial, demonstrating preserving some of the earliest inventions. Criterion number 7 here says it contains superlative natural phenomena or areas of exceptional natural beauty or aesthetic importance. I think that obviously applies. And then number 8 is interesting, which I put in bold here. A record of Earth's history. And this is this one point where it never imagined that we could have heritage sites beyond Earth's boundaries. And of course, that could be amended. And it says, and a record of life and geological processes, which actually could apply in outer space. So I was thinking of the existing UNESCO sites. Are they really so remote like we could imagine our points in space and bodies in space would be? And the answer is absolutely. Look at this. This could be an image on another planet. And it's extraordinarily beautiful and something already appreciated internationally. And so I would also mention that beyond our points of sort of stark beauty, we do have an existing interest in space heritage law specific to space and like present space travel. So in the United States, we've had multiple efforts. They haven't been successful since 2013 to create a national park on the moon to protect the Apollo landing sites. And I know we could have a whole nother session on whether the United States could do that in the eyes of the world, but these bills did not pass. And it was in order to provide for greater recognition and public understanding of the singular achievement in American history. So there's obviously an aspect of patriotism in there. But look at this. It also suggested that the Secretary of the Interior, our National Park Service, would work with NASA and the Smithsonian Institute to ensure that this would happen. And it could employ monitoring. What do you do at a park? You manage its access, you catalog what's there, and you work with other nations. And particularly if you're talking about a World Heritage Site. And it said, let us submit to UNESCO a nomination of the lunar landing site as a World Heritage Site. And as we know, when these are designated that way, we recognize it having universal value to all of us. And then in January last year, President Trump signed into law the act of One Small Step to Protect Human Heritage in Space. It isn't regulatory. It's a little bit loose, providing some oversight to NASA. All of these apply some existing guidelines out of NASA that I'm going to show you in a second. And it refers to commercial space activities and best practices in heritage preservation, but it doesn't provide any licensing at this point. So it is actually a small step. Those guidelines that I was mentioning are from 10 years ago. And you can see here this image of the moon where you could just imagine where they'd have points like the astronaut's footpath and the first landing and where the flag is, where they might want to have sort of conservation efforts. So here in the early report in the guidelines, it stated, because there's no precedent for this situation throughout nearly 50 years of space flight, there are no guidelines or requirements for spacecraft visiting these areas. and what they would do with the lunar hardware that's there. So interim guidelines suggest that until more formal guidance is developed and perhaps a multilateral approach, this is the best that they could do. And it's designed to essentially inform future endeavors and to create dialogue with foreign space agencies. So there's some brainstorming going on. But I'd also suggest that there's already existing both in Antarctica and in terms of the law of the seas, when we don't necessarily have clear sovereign interests in the space. And so, and what happens there with heritage sites? So in Antarctica, ICOMOS, again, this International Council on Monuments and Sites, has an International Polar Heritage Committee. They have 92 historic sites and monuments, including like Scott and Shackleton's huts, memorials to scientists, for example, from India and other nations that have lost their lives in some of their tremendous work. And one of the reasons that this is even there is because before the 1959 Antarctic Treaty, there was some evidence that competing nations were defacing each other's historic sites on the continent. And so one of the very first things they discussed at the treaty meetings was cultural and natural heritage preservation. And today they've also added ongoing conversations about environmental conservation. And agreeing to respect each other's interests in heritage and their combined interests in heritage has actually promoted peace. And I think that this could be a model for space. And it's also not only in Antarctica, but something we've seen 40 years later in our UNESCO Convention on the Protection of Underwater Cultural Heritage. And so this promotes underwater archaeology, conservation, all the same ideas. It encourages state parties to join forces and in the protection, management, and valorization of humanity's common underwater cultural heritage. And it's an act of cooperation, you know, as much as it might seem like it's tourism or it's luxury, it's just these rich people. No, we have a legal framework to talk about the joy of tourism and exploration and appreciation of heritage for all of us. And I also want to mention that it can be very pragmatic. So this particular convention seeks cultural heritage as a tool in favor of cooperation, and it really does do that. So in 2021, we had joint maritime archaeological training in 8 Arab countries. And in 2020, a joint virtual maritime exhibition amongst 8 Latin American countries. It's a tool of diplomacy. The Artemis Accords, however, present some concerns, and there is certainly with respect to the intersection of cultural heritage and commercial enterprise. So I just want to touch on that before I conclude. So the Artemis Accords include protection of space heritage sites expressly. You already know the number of nations that are involved. It's not 200. And the White House in January 2021 said that the accords represent a shared vision for principles grounded in the Outer Space Treaty, creating and facilitating exploration and commercial activities. And that has already been touched on today as a concern. But you know, what you'll see in this is that it doesn't really define what it means by a heritage site. There's discord on the role of commercial exploration, of course, with Russia, and some of the pushback that's happened. We've just seen this fracture that's occurred that it has yet to be decided. So space tourism itself could be commercial exploitation. It could be, and we've seen this with who can actually fund the tourism itself. They have other interests. So in 2020, the United States Executive Order on Encouraging International Support for the Recovery and Use of Space Resources did mention that this long-term exploration is going to require partnership with commercial entities, and the United States doesn't view outer space as a global commons. So, and of course, you could look at a basic Oxford English Dictionary definition of that term, and it would include unowned natural resources such as the oceans, atmosphere, and space. So I agree with the comment that was made about the Wild West, and mining in particular has been a concern for designated World Heritage sites on Earth already. Part of the problem is that land use regulation is often locally determined. The mining interests are locally determined, but designation of heritage sites is global. And so you're going to run into conflict. This is one kind of awful quote from a law review article criticizing UNESCO, not the author of the article, but that the Organization of the United Nations is anti-American, anti-constitution, bent on one world government, and claims control over these World Heritage sites. And so you can just see the conflict amongst people and their livelihoods at the local level. The nomination of World Heritage Site status also is typically insufficiently representative at the national level. In other words, where they designate the sites may not have enough buy-in and voices of the local people affected. And I think that's important for all of us to recognize. And the convention itself is kind of unclear on whether mining is restricted at the heritage sites. Sometimes it's actually lawful. So we haven't even sorted that out on Earth properly. So the unique attributes, and I'm concluding here, of natural and cultural heritage sites in space. If space is stateless, not necessarily obviously the persons and the equipment going out there, but if the space itself and the land that we're talking about, it's going to require a collaborative duty, but UNESCO already is a collaborative endeavor. I do think it will primarily be about natural heritage preservation in space, rather than, say, treating the ISS as a museum at some point. But I do worry about space piracy and having fewer resources to protect those sites as we would on Earth. The term world for the World Heritage Convention may also need some better terms of art, and including suborbital, orbital, and of course outer space sites to be inclusive of that, and clarifying all the sovereignty interests. Big task with respect to what may be a conflict between commercial interests and heritage preservation, but they also could be in sync. And it also could be that commercial entities, as a measure of goodwill, seek to help build heritage preservation. And so I just want to thank you all very much and share with you how much we all enjoy our whole history of looking up and treating our skies as a space park anyway. I think we've already had one and hope to grow more. So thank you very much.
Thank you so much, Professor, for that enlightening speech.
Good afternoon, everyone. I hope you enjoyed your break. My name is Akshanu Haria, and I will be taking over for Rohit Gupta for the second technical session. And for that, our first resource person today is Professor Carl Grossman. Professor Carl Grossman is a full professor of journalism at the State University of New York College at Old Westbury, who has specialized in practicing investigative reporting and in his 43 years at the college teaching it. Space has been a special investigative focus. He is the author of the books Weapon in Space and The Wrong Stuff, and the writer and presenter of the TV documentary Nukes in Space, The Nuclearization and Weaponization of the Heavens. He was a co-founder of the Global Network Against Weapons and Nuclear Power in Space. Honors Grossman has received for journalism include the George Polk, the Generoso Polk, James Allenson, Leo Goodman, and John Peter Zenger Awards. He has been the host for 31 years of the TV program aired nationally in the United States, Enviro Close-Up with Carl Grossman. He has given presentations widely on space issues, including multiple times at the United Nations and before members of the British Parliament. And today, before us, he will speak on the topic, Can Space Tourism Coexist with Space Being Turned into a War Zone? And now I yield the floor to Professor Carl Grossman.
Thank you so much for the introduction, and thank you for inviting me. Good afternoon in India. I'm speaking to you from Long Island near New York, where there's a blizzard. We're supposed to get nearly 2 feet, if not more, of snow. Let me start off now talking about another blizzard, the push to arm the heavens. The push to turn space into a war zone could spell goodbye to space tourism. The drive underway, led by billionaires Jeff Bezos, Richard Branson, and Elon Musk, is seen as only a start to space tourism. Meanwhile, there's the push led by the United States, my country, to turn space into a war zone, and this despite the Outer Space Treaty of 1967 that set space aside for peaceful purposes. As then U.S. President Donald Trump declared in 2018, as he advocated for formation of a U.S. Space Force, it's not enough to merely have an American presence in space. We must have American dominance in space. The following year, he signed the National Defense Authorization Act of 2020, establishing the Space Force as the 6th branch of U.S. Armed Forces and saying, space is the world's newest warfighting domain. The Space Force, Trump said, would help the U.S. control the, this is the quote, ultimate high ground. Then, at an unveiling of a Space Force flag in the White House, Trump said, space is going to be the future, both in terms of defense and, catch this word, offense. Trump's successor, U.S. President Joe Biden, has, sadly, not rolled back the U.S. Space Force. Several Democratic members of the U.S. House of Representatives last year introduced the No Militarization of Space Act that would abolish the U.S. Space Force. The prime author of the legislation, Representative Jared Huffman of California, called the Space Force costly unnecessary. He went on, the long-standing neutrality of space has fostered a competitive, non-militarized age of exploration every nation and generation has valued since the first days of space travel. But since its creation under the former Trump administration, the Space Force has threatened long-standing peace and flagrantly wasted billions of taxpayers' dollars. It's time we turn our attention back to where it belongs, said the congressman, addressing urgent domestic and international priorities like battling COVID-19, climate change, and growing economic inequality. The measure got nowhere. That was not surprising, considering that most Democrats in the U.S. House of Representatives and Senate, and nearly all the members of the other major political party in the U.S., the Republican Party, voted for the National Defense Authorization Act of 2020, providing for the Space Force's formation. And the U.S. Space Force is moving forward. Last year, it requested a budget of $17.4 billion for 2022 to grow the service, reported Air Force magazine. A headline of the story in that magazine, Space Force 2020 budget adds satellites, warfighting centers, more Guardians. This term guardian was the name adopted by the U.S. Space Force in 2021 for its members. One after another of U.S. Air Force bases are being renamed U.S. Space Force bases. In 2020, the Space Force received its first offensive weapon, satellite jammers, reported American Military News in 2020. Soon afterwards, the Financial Times ran a story, the headline, U.S. military officials eye new generation of space weapons. In 2021, the headline on C4ISRANET.com website, which focuses on U.S. military developments, was Space Force wants to use directed energy systems for space superiority. As to the impacts of war in space, Bruce Gagnon, coordinator of the Global Network Against Weapons and Nuclear Power in Space, relates the projection of the late Edgar Mitchell, the sixth U.S. astronaut to walk on the moon. Gagnon said in 1989, during one of our campaigns against NASA plutonium launches, NASA's launching of plutonium-powered space probes, we had a rally at the Kennedy Space Center in Florida, and our keynote speaker that day was Apollo astronaut Edgar Mitchell, one of the moonwalkers. And he came and said, if there is one war in space, it'll be the one and only. He said, because we will create so much space debris or space junk from all the destroyed satellites and things like that in space, that there literally would be a minefield encircling the planet. He called it a piranha-laced river. This is Edgar Mitchell, the astronaut, the U.S. astronaut, and we would not be able to get through. A rocket would not be able to get off this Earth through the minefield. So, said Bruce Gagnon, it's insane to think about having a war in space. Gagnon has also spoken of how space warfare would mean activity on Earth below would immediately shut down. Cell phones, ATM machines, cable TV, traffic lights, weather prediction, and more, all hooked up to satellites, would, said Gagnon, be lost. Modern society would go dark. Also pointing to the space debris resulting from warfare in space was Alexander Chanok in a section titled Problems with Weaponizing Space in an article published in 2013 in the Journal of Air Law and Commerce titled The Problems and Potential Solutions Related to the Emergence of Space Weapons in the 21st Century. Chanok is an attorney. He's now legislative counsel in the U.S. House of Representatives, and he wrote the major problem, he agrees with Edgar Mitchell, is the amount of space debris that space weapons would produce, extremely dangerous debris. Chanok quoted Dr. Joel Primack, professor of physics and astrophysics at the University of California in Santa Cruz, saying the weaponization of space would make the debris problem much worse, and even one war in space could encase the entire planet in a shell of whizzing debris that would thereafter make space near the Earth highly hazardous for peaceful as well as military purposes. And in my written presentation, I quote, and I can jump through this quickly, a number of other experts in space talking about with the weaponization of space, if there's a shooting war in space, we're not going to be able to get up and out into space. The blueprint for international cooperation in space has been the Outer Space Treaty of 1967, which sets space aside for peaceful purposes and declares it a global commons. It was put together by the United States, the United Kingdom, and the former Soviet Union, and has wide support from nations around the world. As Craig Eisenthroth, who was a young U.S. State Department officer, was involved in the treaty's creation, but he told me, I vividly remember him telling me this. We sought to de-weaponize space before it got weaponized to keep war out of space. The Outer Space Treaty of 1967 prohibits in orbit around the Earth any objects carrying nuclear weapons or any other kinds of weapons of mass destruction. For decades, there's been an effort to extend the Outer Space Treaty and enact the Prevention of an Arms Race, the PAROS Treaty. China, Russia, U.S. neighbor Canada have been leaders in seeking passage of the PAROS Treaty, but the United States, through administration after administration, Republican and Democrat, has opposed the PAROS Treaty and effectively vetoed it at the United Nations. And I've been there and I've seen this. A rationale for the U.S. Space Force has been that it's necessary to counter moves by Russia and China in space, particularly development of anti-satellite weapons. Most recently, the U.S. concern about Russia and China moving into space militarily was heightened by Russia in November 2021, when it used an anti-satellite weapon to blow up a defunct Soviet intelligence satellite. Dr. Paul Robinson, a professor of public and international affairs at the University of Ottawa, said in an article on RT, the Russian media network, that the Russian anti-satellite test may be seen as an effort to try to force the United States to recognize its vulnerability and so bring it to the negotiating table. But, said Robinson, this may not work. Now, the history of U.S. interest in space warfare includes the Strategic Defense Initiative. This is the scheme of President Reagan of the 1980s, dubbed Star Wars, predicated on orbiting battle platforms with onboard hypervelocity guns, particle beams, and laser weapons energized by also onboard nuclear reactors. As to why they need nuclear reactors on board these orbiting battle platforms, General James Abramson, the director of the Strategic Defense Initiative, said at a symposium on space, nuclear power, and propulsion in 1988, without reactors in orbit, and he's speaking sarcastically, there's going to have to be a long, long extension cord that goes down to Earth, to the surface of the Earth, to bring up power to energize space weaponry. Chanok's article in the Journal of Air and Law and Commerce included a section headed Potential Solutions. It began, there are a number of different views on how the United States should address the issue of space weapons. On one end of the spectrum, he wrote, is the view that the United States should abstain entirely from developing space weapons and help construct an international legal regime to restrict them. On the other end is the notion that an international legal regime would prove futile, and the United States should continue developing space weapons in order to dominate the new frontier. He writes about space doves who believe that the U.S. should not develop space weapons, but should find ways to restrict all space weapons. And he cited among the, in quote, doves, Nina Tannenwald, who has held that the U.S. should use its power and position to create an operational regime for space based on the rule of law. She's been a senior lecturer in political science at Brown University. She wrote an extensive article in the Yale Journal of International Law back in 2004 titled Law versus Power on the High Frontier. The article's conclusion began, the challenge the international community faces in space today is the imminent collapse of a 45-year-old tradition of restraint with regards to military activities in space. The U.S., she says in her piece, should use its power and position to support creation of an operational regime for space based on the rule of law. Security in space will be more effectively achieved through a rule-based regime than through the deployment of destabilizing weapons systems. However, Chanok in his piece stated, although space doves have many valid arguments for reducing the danger of space weaponization. In reality, it is unlikely that their ideas will prevail. He noted the U.S. Congress has consistently rejected any bill that tries to ban the use of space weapons. Channock cited bills that sought to ban space weapons and failed. These are U.S. bills, including one introduced in 2001 by Congressman Dennis Kunitschek of Ohio, which did not garner a single co-sponsor. Internationally, since the creation of a U.S. Space Force, several nations, including the United Kingdom, have begun to emulate the U.S. in space military posture. How to Halt the Space Arms Race was the headline of an article in the British publication, The New Statesman, and this is last year, 2021. It stated, this year, the UK launched its own space command, with military chiefs acknowledging space as a domain of conflict, co-equal with air, land, sea, and cyber. Could space be demilitarized, asked the article. Not a chance, say the experts. We're stuck, and while polite verbal fencing takes place at the UN, the major powers of the 21st century are engaged in an unprecedented expansion of military power in space, leaving the vast majority of countries powerless. Most of humanity as passive spectators in the Earth's orbit, increasingly polluted with debris from exploded satellites. This pessimistic forecast need not be. My conclusion here, the Outer Space Treaty of 1967 was and is a visionary document. War on Earth is terrible enough. It must not be brought up to the heavens. This will take continued political will and international pressure to preserve and extend the Outer Space Treaty. Especially in the United States, this will require action at the grassroots because the two major political parties in the U.S. have joined in a bellicose stance on space, supporting it becoming a war zone. Every year, the Global Network Against Weapons and Nuclear Power in Space, founded in Washington, D.C., 1991, and the leading group internationally challenging the weaponization of space, holds a Keep Space for Peace Week with actions around the world. Meanwhile, there are nations around the globe that have, unlike the United States, adopted a peaceful stance, as reflected in their support for the proposed Paros Treaty. We must indeed keep space for peace. Can space tourism coexist with space being turned into a war zone? The answer is no. And with a shooting war in space, it will not only be space tourism that would be kissed goodbye. That's my presentation. Thank you.
Thank you. Thank you so much, Professor Carl Grossman. That was indeed an enlightening presentation on the effects that a harmful space agenda can have and how we should all be wary of such. For our next speaker, I would like to invite Professor Dr. G.S. Sachdeva. Professor Dr. G.S. Sachdeva is a pioneering scholar on space law in India for the last 4 decades. He has 8 books to his credit and has contributed over 60 articles in edited books and law journals in India and abroad. He has a master's in economics from Delhi School of Economics, Delhi University Law graduation from Nagpur University, and he's a gold medalist as well there. He also has a PhD in international law from JNU Delhi. He is currently an adjunct professor to Nasser University of Law, Hyderabad, and was formerly an adjunct professor to the School of International Studies, JNU, New Delhi. He has participated in international research studies and is a member of the study group 3.26 of International Academy of Astronautics in Paris. He also visits as a guest faculty in air and space law to some universities and institutions. And for today, he will be talking about on the topic space tourism possible crimes, and their adjudication. I now yield the floor to Professor G.S. Sachdeva.
Thank you very much. I respect the professors who have already spoken on the subject, one aspect or the other, and perhaps are sleeping in their room because of the time gap and all that. But nevertheless, I speak on a subject which I have to visualize. It's not all of it is apparent, but I've got to visualize and speak as what exactly would be the crimes that will happen in space. And how exactly we'll be able to do the adjudication of these once these happen, and the problems which will be connected with both of them. Now, quickly getting on, I would say that commercial space travel has already started with Virgin Galactic, Blue Origin, SpaceX, and all that. Once space travel starts, I think space tourism would not be far behind, because any person who goes into outer space, or perhaps to the celestial bodies, moon or the Mars, would like to have some sort of a entertainment or fun or games or whatever. We discussed it. So for the purpose of space tourism, I had a PPT. Is it available? Otherwise, I can do without it. All right.
Yes, sir. I'll just present it.
All right, never mind. I'll be able to manage without that. Perfect. Now, once the space tourism starts, I think the early indications are that the ISS, the American quarters of the ISS, are out for lease and for commercial purposes, because American quarters are being closed and there is not going to be any budget for its maintenance after 2024. So that may likely be one of the first in orbit hotels or motels or resorts or whatever you call it. Then there would be some sort of resorts which will come up on the celestial bodies like Moon and the Mars. There would be problems. There are challenges because, as it has been said, that these celestial bodies are stateless. You cannot occupy them. And there is no way where sovereignty can be exercised over these. Hence, there would be needs for leases in order to build up some sort of hotels or resorts. But before I take on to the crimes and other aspects, thank you very much. Thank you very much. Before I take on to the other aspects, I would like to discuss what are the assumptions. What are the assumptions of viability? Is space tourism really viable? I believe it is. And I give you 5 reasons for this. The first is commercial viability. And the private sector has already proved this fact of commercial viability by sending Dynasty to out. And today we have 3 space carriers who are willing to take tourists to the outer space. The other is financial affordability. I agree that Dynasty 2 went at a very high cost of billions. But today, as Virgin Galactic had quoted, it's just going to be 2.5 million or something per passenger. But with competition coming in, it's going to reduce further. So that means the tariffs for space travel would really become gradually much lower, economical, and perhaps affordable. The next is technical infrastructure. If we have to have visits to the outer space and to the celestial bodies, we need some space ports which will have to come. And this is where we'll discuss the role of various organizations. The next one is the standard of acceptability, acceptable safety. And I think demonstrations made by these pre-installation and the other flights shows that safety has come up fairly well compared to what it was for the shuttle flights of America. And the last of all, there is need for some sort of an entertainment, because if tourists go outside, they would have something for leisure and pleasure too. So, as we talk of the crimes, we have to find it out. What will be the nature of crimes? And to find out the nature of the crimes, or to make a distinction between that, I would like to discuss what are the components of space tourism, because each component would have a different type of a crime. At this stage, in my introduction, I would also like to say I'm using the word crime in a very loose sense. It's a very generic sort of thing. And the crimes would mean near crimes, conflicts, liability situations, similar sort of a thing. I'm making this as a loose generic term to call it crimes, not all what I have said now. The first component, or perhaps the first stakeholder in space tourism, would be the tourist passenger themselves. And that passenger, in order to go to the outer space, would need certain amount of discipline. And he cannot be neither careless nor casual. Space is a very hazardous and unsparing environment, and any sort of a casual attitude can be dangerous. The next is space carriers. Space carriers have to work for safety, they have to work for lower tariffs, and they got to work for liability in case of accidents. The third component is hospitality business. The hospitality business, there would be places which are safe and secure to stay as residents. And it will also be that people have something to keep them occupied and engaged. Tourists will have a lot of time otherwise. So this is what activity which will have to be developed by the hospitality business. There are certain responsibilities of the authorizing state, launching state, or authorizing state from where this activity of tourism starts. That would be authorization and continuing the supervision. And in the end, I would like to say that United States has got a role. They have a certain responsibility also. In case space tourism comes up, there would be need for international cooperation and certain institutional setups like space traffic management, which is not going to be an individual affair of any country or a space carrier, but it has to be a unified information system of space situational awareness. Apart from that, there is need. If at all we go to the celestial bodies, we need what we call as spaceports to come back also, land and come back. With this sort of a discussion on the components or stakeholders, I come to the crimes, which is the first aspect, is the crimes by the humans. Humans, wherever they go, they carry their basic nature with them, the basic instincts with them, the pugnacity and the heights, and particularly where the grouping is a multinationality, multi-ethnic, the problems come up in understanding and behavior. The third would be that each stakeholder, what is the quantity and quality of his interaction and involvement in the entire business. And the third would be there are differences in perception. We all look at laws could be different, perception could be different, attitudes could be different, social mores could be different, cultural background could be different, and all these are likely to create a situation of conflict. Then again, the stress of space environment is not minimal. There is velocity, there is spiraling, there is G factor, and all these add to the basic body biology as well as the mental state. And this can be at times very awkward. And last of all, if people go and stay outside, they'll be away from their own familiars, and this can be a problem. Now, coming to the crimes, I'll consider first the crimes by the individuals. That means the crimes by the tourists or the guests themselves. They could commit the crime individually, could be jointly, could be collectively, something like a law and order problem, could be conspiratorial with a conspiracy something, could be a provocation, could be revenge, or it could even be mental harassment when you're living in small, compact, claustrophobic environment. Then are what we can call as the near crimes by the space carriers. Space carriers would have a responsibility to look into the security, and any deficiencies in the security of the guests and the passengers would be really unpardonable. Similarly, there could be lapses in the standards of passenger safety. Safety is one of the most important aspects in space travel and cannot be compromised at any stage in any manner for any reason. The next would be compromise on space worthiness of satellites. This is again, private companies have different motivation and they'll cut corners at various places in order to make profits or to save costs. And the last of all is neglect and operational duty in any space activity by any of the employees is unpardonable. I'll quickly go over the crimes by hospitality business. They must provide a fail-proof infrastructure for residents where people would stay. Second would be, there should be no deficiencies in the safety of the guests, no leakages, no radiation, and things like that. Third would be that there should be adequate arrangements for medical care of guests. Because it's not that the human beings will not get sick in outer space. It can happen, it has happened, it will happen. So if this is so, we need to do it. And lastly, they must have a plan for evacuation in events of accidents, distress, or emergency. Next is certain breaches of state responsibility are partly covered. I'll just say that. First is the breaches would be where there's a breach of space law treaty. Then there could be deficiencies in discharge of mandated responsibilities under the Outer Space Treaty, which is authorization, registration of launches, and continuing supervision. Any lapses can be serious and can be dangerous. Then there would be willingness to provide shelter to others in distress or in accident. And then last of all, ensure compliance of norms for avoidance of pollution. Now I just make a small brief reference to crimes against humanity. I'll talk of 3 points only. One is, if terrorism has come on the earth, it will not take time before it reaches the other celestial bodies or gets somehow into the space travel. And that is, it will be unpardonable for the terrorists. My time is over. The second point which I have is, if at all the programs for evacuation in case of emergencies are not properly laid out or executed, it can be torture in space the people who are left over. And the last of all, whatever we are doing to send our rockets into space, they leave certain carbon footprints. And these have affected the ozone layer in atmosphere, and with increasing number of satellites going, we find that our ozone layer gets affected, and ultimately we'll be having holes all around sun. Now coming to education, next slide. We have education for various reasons. One is we want deterrence. We want to exonerate people, say that they are not guilty, or for reformation, or for punishment. And last of all, to curb recidivism, which is a recurrence of crime. Now, in order to have a smooth adjudication, we find that the existing space law is rather inadequate, because at the time when this particular law was crafted, crimes was not on our mind at all. And hence, there is need to depend upon the principles of international law, like the doctrine of nationality, doctrine of universality, and the doctrine of extraterritoriality. So if at all we have to have it, we need a special treaty, number one, which is devoted not only can be for the crimes, but could be a broader comprehensive treaty also, which shall cover how the adjudication of crimes will take place. Second would be that outer space is an ungoverned domain. There is no sovereignty, there is no state. Any domain which is really populated like this with the tourists and workers would need to be governed, and that's where we need government. I'll discuss a little later how we do that. And the third would be there will be need for institutional support. I'll discuss that a little later. And all these initiatives need to come from the United Nations. Now coming to the administrative machinery, since there is no state in outer space or sovereignty in outer space, we need to have some sort of a governance. And perhaps my suggestion would be, in case we can provide trusteeship council, which is more or less defunct today, it could take on the task of administration, management, and governance of outer space. The next would be jurisdiction. Jurisdiction is a very, very touchy subject, and it can be governed in various ways, as I said, by the doctrines of territoriality, universality, etc. These are the different principles. But there are other factors come in, like is evidence available in that country which seizes that particular case? Or there could be conflicting claims of extradition, where the national is being claimed for extradition to the country of its own origin or preference. So if at all we have a problem, and if the jurisdiction fails and there is no trial done for the criminal, then we have to have, wherever there are delays or hassles, we could possibly think of having an international court of space crimes. It need not be an independent court. It could be a bench of ICJ, International Court of Justice, or International Court of Crimes. The reason would be that independent court would be able to give better justice and faster justice, which we would all expect. And in the end, I would like to say, what needs to be given is not only the legal justice. What needs to be given in situations of international gatherings and groupings and all that is also social justice. Why I say there is need for social justice? Because we all have different concepts of legal systems, legal codes, and our own social norms. To perhaps give a small example, Germany doesn't have a concept of what we call as contributory negligence. Or perhaps I would call Russia and communist countries do not have a developed jurisprudence of compensation. And perhaps I could give you one more example, that rape has different connotations in different countries. In our normal Eastern and Western countries, man is the culprit. But you take it on to the Islamic or the Sharia law, you will find it's the woman who is the culprit. And the woman gets punished for, number one, losing chastity, diluting fidelity. And in the law, under the Sharia law, she can be hanged or even stoned to death. I've just given a few examples. How our perception of law, how our perception of judicial systems are something like a jury system, inquisitorial system, adversarial system, Islamic system of law, where a woman's evidence is considered to be half the value of that of the man. So what we need to give in the end is not only justice through court, but a social justice which is acceptable and in perception becomes a justice acceptable by both parties and the humanity at large. Thank you very much.
Very good afternoon. I am Anushka Mishra, a final year student from the West Bengal National University of Juridical Sciences. Without much ado, we head with the third technical session for our conference today. We have our first presenter for this session, Professor Dr. Dave Webb, who is the convener, Global Network Against Weapons and Nuclear Power in Space. He would be presenting and enlightening us on the topic of environmental impacts of space tourism. Over to you, sir.
Thank you very much. Thank you very much for inviting me. And it's been a really interesting, I think, conference so far. I should just say I'm an engineer and campaigner rather than a lawyer or a legal expert. So I've been bowing to all of you people who've been very enlightening on that regard. SpaceX Corporation for around $100 million. Also earlier last year, we saw well-publicized suborbital passenger flights of Virgin Galactic and Blue Origin, who took passengers into space and back in a few short trips. Virgin Galactic made the first of these on the 11th of July, and Virgin Galactic expects commercial flights to begin by the end of this year, and the company sold around 600 tickets for $200,000 to $250,000 each from 2005 to 2014. And sales resumed after Branson's flight at a higher price of $450,000, and another 100 have been sold since then. On July the 20th, Blue Origin's New Shepard rocket took off with Jeff Bezos and his brother, 18-year-old student Oliver Deeman, the son of a Dutch financier, and 82-year-old Wally Funk. And a second Blue Origin flight took actor William Shatner, Captain Kirk, aged 90, into space on the 13th of October. These two trips reached an altitude of 107 kilometers, just above the 100-kilometer Kármán line, where aeronautics gives way to astronautics, and which is deemed by many to be the edge of space. I think there's already been a discussion about this. There are the two interpretations of where space begins. NASA has it at the 80-kilometer height, where they call people who've gone beyond that as astronauts. The Kármán line is generally accepted to be the edge of space. And the two different spacecraft reached the two different lines. So Blue Origin is looking to launch paying travelers into space, also using the reusable New Shepard rocket and a passenger capsule on top for a reported $200,000 and $300,000 ticket price. Elon Musk's SpaceX company is also offering up its Crew Dragon spacecraft for chartered orbital flights. And on 16th of September, they carried 4 American citizens into Earth for 3 days. The flight was called Inspiration 4 and was privately chartered by billionaire Jared Isaacman. It became the first private citizen crewed orbital mission. So SpaceX has also been delivering cargo to and from the International Space Station since 2012, and in 2020, it began transporting astronauts there. It's estimated that NASA will be paying SpaceX an average of $58 million per astronaut, compared with the $81 million it costs for flights on Soyuz rockets. And SpaceX is also offering commercial trips to orbit the Earth and the Moon. Elon Musk's ambitions are far-reaching, and he plans to use SpaceX's huge Starship rocket to fly as many as 100 people around the world in minutes. Claims are that flights from New York to Shanghai would take 39 minutes rather than the 15 hours it takes by airplane. Musk also has plans for colonies on the Moon and Mars, which would also likely eventually include hotels for tourist trips. As long ago as the 1960s, Pan American World Airways had been pushing the idea of private spaceflight, and a model of an Orion 3 space clipper with a Pan Am logo was used in the 1968 film 2001: A Space Odyssey. At that time, the idea was more fantasy than fiction, but an Austrian journalist asked to book a flight to the Moon, and Pan Am announced that they were going to offer commercially operated passenger lunar flights 5 years before the Apollo 11 landed on the lunar surface. However, during the Apollo missions, interest grew, and eventually Pan Am had a waiting list for tickets of about 100,000 people. However, the company went bust in 1991. So there doesn't seem to be, the point of all this is that there doesn't seem to be a shortage of people willing to pay to go into space, and companies are looking to sell very expensive tickets to help them. But as things develop and launch systems become cheaper, you may not have to be a billionaire to afford a ticket, just very wealthy. The company Axiom Space Inc. are even looking to construct their own space station and provide spaceflight services to individuals, corporations, and space agencies. Currently, though, the major operators are Blue Origin, Virgin Galactic, and SpaceX. A recent report by the Swiss multinational investment bank UBS does see the space tourism industry growing rapidly, with high-speed travel via outer space competing with long-distance airline flights. They anticipate an annual market of at least $20 billion, with space tourism having a $3 billion share by 2030. However, as the number of launches increase, effects on the environment also increase, and there are some important environmental issues now being raised. During the launch process, rockets burn through a huge amount of fuel, and there are a range of different propellants used. Many rockets use a mixture of kerosene and liquid oxygen, while others use liquid hydrogen or some other more complex compounds. This table shows the various fuels used by current crewed spacecraft. Hypergolic propellants, so-called, consist of two components, a fuel and an oxidizer, that simultaneously ignite when they come into contact. One such combination is UDMH, or unsymmetrical dimethyl hydrazine, and TCO, nitrogen tetroxide. UDMH was called devil's venom by Soviet scientists, and a UN Development Programme review in 2020 reported that it had caused severe environmental damage to a huge area around the Baikonur Cosmodrome launch site in Kazakhstan. UDMH is highly carcinogenic and is emitted as the first and second stages of Russia's Proton rockets. Research has been published on this, but according to the UN review, UDMH and byproducts can stay in the soil for decades. Let's just go back to the previous slide. Although Russia no longer uses it, UDMH also powers the first 4 generations of China's Long March rockets, and generations 2 to 4 are still being used to service their space station. NASA used APCP, which is ammonium perchlorate composite propellant, mixed with polybutadiene acrylonitrile to give extra lift required to launch the space shuttles. Following several shuttle launches, large numbers of fish were found dead in nearby waters, and investigations showed that the space shuttle emissions may temporarily have made water slightly acidic, causing those deaths. Rocket exhaust clouds generated during launch also contain reactive chemicals such as hydrochloric acid and aluminium oxide that become mixed with water used to cool down the launch pad and rocket. This cloud then spreads out, affecting soil and water quality and damaging vegetation. In 2005, there were reports that levels of perchlorate in breast milk and vegetables were high in many areas near launch sites. Perchlorates occur naturally, but indications were that rockets were contaminating water supplies, and perchlorate has been linked to thyroid ailments and is considered particularly dangerous to children. Rocket engine exhausts also contain gases and particles that can affect the Earth's climate and the stratospheric ozone layer that protects us from ultraviolet rays from the sun. Let's look at ozone depletion first of all. Here you can see the various layers of the Earth's atmosphere. Rockets travel through the stratosphere, which contains the ozone layer that protects the Earth from dangerous ultraviolet rays, through the mesosphere and into the thermosphere, where the temperature rises quite rapidly in the extremely sparse atmosphere. The Kármán line is seen here at the bottom of the thermosphere. This slide from a presentation by Robert Ryan at University College London and colleagues show the mass of pollutants emitted from rocket launches and debris and re-entries for each month of 2019. The key pollutants are nitrogen oxides, hydrochloric acid, chlorine, aluminium oxide, and black carbon. They found that rocket pollution had the potential to undermine about 20% of the gains made by the Montreal Protocol to protect the ozone layer, as shown here. In the past, rocket launches have been assumed to be not much of a threat to the global environment because the space industry was small and unchanging. However, today's rapid growth and the lack of research and oversight is cause for growing concern. Global warming, CO2, alumina, black carbon, and water vapor are very much a problem. Space travel also contributes to global warming and in particular produces significant amounts of carbon dioxide, alumina, black carbon, and water vapor, dependent on the type of propulsion used. This table from Stuart Parkinson of the Scientists for Global Responsibility in the UK shows conservative estimates for carbon emissions of Soyuz, Falcon 9 and Space Launch System vehicles. There's no publicly available data for Virgin or Blue Origin vehicles. However, very high carbon emissions are associated with liquid oxygen and hydrogen fuels used by Blue Origin because of the very energy-intensive processes needed to create and store the fuel at very low temperatures. It's estimated that for each ton of liquid hydrogen used, about 25 tons of carbon dioxide equivalent is emitted. This compares with about 3 tons of carbon dioxide equivalent for aviation fuel. It's also been estimated that the launch of Blue Origin's New Shepard spacecraft is responsible for 330 tons of CO2 equivalent being released. This slide shows how the carbon footprint of a space traveller compares with the annual production of a UK citizen and that needed for a sustainable lifestyle in 2030. So one space tourist flight is equivalent to 10 times the annual carbon footprint of a UK citizen and 40 times that required for a sustainable lifestyle in 2030. And there are other concerns. The release of alumina particles, black carbon and water vapor into the atmosphere also contribute to global warming. according to a study carried out by Jessica Dallas and others at the University of New South Wales. The liquid oxygen and liquid hydrogen mix used by NASA and Blue Origin produce water vapor, which is the biggest contributor to the natural greenhouse effect. And although it may have little effect at ground level, at high altitudes the effects are large as they impact the mesosphere and ionosphere. High altitude cloud blooms attributed to space launches have been frequently observed. Other rockets that use kerosene, as in SpaceX's Falcon 9 and Russia's Soyuz rockets, produce alumina and black carbon or soot particles in the stratosphere. Rocket engines emit large amounts of black carbon compared to a modern jet engine. During a flight through the stratosphere, black carbon can account for several percent of the rocket emissions, but it's only about 1% of the emissions from a modern jet engine. In 2018, rockets emitted about 225 tons of black carbon particles into the stratosphere, which is comparable to the annual amount of black carbon emitted by global aviation. Meanwhile, solid-fueled rockets have emitted over 1,400 tons of alumina particles into the stratosphere. Black carbon has been found to play a significant role in global warming. Rocket launch particles, a region important for the weather, stay there because they are so small and they accumulate for 3 to 4 years. However, the overall impact is complex, depending on how they're found, where they are found, and black carbon and alumina particles can also reduce the intensity of the solar flux at the top of the atmosphere and so contribute to a cooling of the Earth's lower atmosphere and surface. Unraveling the complexity and accurately addressing the potential effects of the coming surge in rocket emissions will require sophisticated computer modeling, which has yet to be performed. To conclude then, space tourism is one of the biggest drivers behind spacecraft development. However, the fuels used and the journey through the atmosphere are environmentally harmful and contributing to the global tragedy of climate change. And it's not necessarily states that are pushing this industry. Much of the work is from billionaire entrepreneurs who are exploiting the general excitement of exploration and adventure that comes from traveling to the unknown to grow their activities and their income. And these activities do not come cheap. So space tourism is just another example of the huge global inequality of carbon emissions, whereby the richest 10% of the world population are responsible for almost half of the total emissions, and the poorest 50% are responsible for 10%. Most scientists agree that more research is needed into the effects of space launches on the Earth's atmosphere and how much they contribute to climate change. Although it's currently something that only the super rich can participate, either as supplier or consumer, space tourism is set to grow significantly, possibly causing considerable amount of environmental damage. Article 1 of the Outer Space Treaty states that the exploration and use of outer space shall be carried out for the benefit and in the interest of all mankind, as we've heard earlier on. And Article 7 states that the state parties are internationally liable for damage on the Earth in air, space, or in outer space, including the moon and other celestial bodies. However, when the treaty was drafted, the environmental effects of space launches themselves were not seen as an issue. Also, although the core objective of the United Nations Environment Programme are to serve as an authoritative advocate for the global environment, to support governments in setting the global environmental agenda, and to promote the coherent implementation of environmental dimension of sustainable development within the UN system, as well, I don't see anything else in that kind of aspect which covers the problems of space contamination. There is the 1972 Convention on the International Liability for Damage Caused by Space Objects, but this refers to loss of life, personal injury, or loss of or damage to property, not the environment. There are no environmental or safety standards for space launches and no system to monitor them and ensure that launches and journeys through the atmosphere are safe and free from harm. So until we have know a lot more about the environmental effects of space travel, the precautionary approach is needed. In order to protect the environment, the precautionary approach shall be widely applied by states according to their capabilities where there are threats of serious or irreversible damage. Lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. This was accepted at the 1992 Rio Earth Summit and should be used as widely as possible. Otherwise, the richest few will continue to endanger the survival of the poorest many. Thank you very much.
Ahead, I would request Dr. Martha Meya Kaiser, who is a member of the Board of Directors of the International Institute of Space Law, to present on the topic of keeping outer space safe for human presence. Over to you, ma'am.
Thank you very much. Can you listen to me? Can you listen to me? No?
Yes, yes, you're audible.
Okay.
Yes, you're audible.
So I'm going to take over the screen. So I don't know what to do here. So you have my presentation.
Martha, if you'd like to share from your side, you can do that actually. There's an option present now. You can see that actually there's an upward arrow mark. Upward arrow mark.
Can you see that now?
Not yet. You have to. Yeah, now it's coming. Now it's coming. Yes. Yes.
Okay. So can you see my presentation?
Yes,
yes,
it's visible.
Okay.
Yes, it's visible.
So when tourists are going to, I don't know, I'm going to the next one. I don't know why they have some strange.
Okay. If you can click on the next slide, I think it should be working. Take your cursor there and click on the next slide. Try to do that.
So, do you see the next one?
Yes, we can see that.
When tourists are going to venture into outer space, it is now time to start protecting outer space for safe travel. Before the first humans were sent to outer space, there were many concerns regarding how they could survive. Concepts and technologies were developed to protect astronauts from the hostile space environment. Ironically, the increase of space activity in the last years has created a new element that is now threatening not only traditional human spaceflight, but the starting space tourist industry. As it has been seen, the few tourists who visited outer space were only in low Earth orbits. This presentation focuses on this orbital area. To enable the development of the space tourist industry, it is necessary to understand the threat of an increasing number of space objects and how to counteract. In the year 2021, more than 1,800 spacecraft were launched, a record number since the beginning of the space era. This graph shows the satellites launched to low Earth orbits, more than 1,750, and about 90% of these satellites were small satellites. The US Federal Aviation Administration has a classification of satellites according to their mass. Satellites with 600 kilograms and less fall into this category of small satellites. To spare weight, very small satellites do not have propulsion systems and guidance systems. Objects orbiting at very low Earth orbits do not represent a big problem at the moment. With short duration missions, they have a short orbital life of some weeks. However, the higher the satellites without propulsion systems are orbited, the longer they will take to naturally descend and re-enter the atmosphere. The US government considered to limit the orbital altitude to 400 kilometers for those satellites that have no propulsion systems, with the aim to protect the International Space Station and crew spacecraft. This proposal faced resistance from satellite manufacturers and operators, who already had planned years ahead the production and launch of their satellites, and feared a drop in their business performance. This US government's proposal is under scrutiny and may be approved next year. It is highly probable that this proposal will be adopted as a requirement for the licensing conditions of satellites, to be applicable not only for US satellites operators, but also to those foreign operators who hold a license to serve the United States. This rule will benefit the safety of manned spaceflight and space stations of other countries at about and above 400 kilometers altitude. On the other hand, small satellites with propulsion and guidance systems, including those that form part of large constellations like the US Starlink and the British OneWeb constellations, can correct their orbits and also perform evasive maneuvers. Some close encounters of Starlink satellites with other space objects have already taken place. In 2020, a Starlink satellite had a close encounter with a satellite of the European Space Agency. And last month, Starlink satellites, last year in 2021, Starlink satellites had 2 close encounters with the Chinese space station. Usually, institutions that provide data on conjunctions inform satellite operators about collision risks. However, operators have a limited time for coordinating evasive maneuvers, which are largely undertaken manually after email communication among the involved operators. As a complicating factor, satellite ground stations are not suitable as surveillance infrastructure to find and track the increasing number of space objects. We have 5 space treaties that enjoy vast recognition of states performing space activities. On the protection of health and life of astronauts, the other space treaty and the rescue agreement stipulate that the states parties that render all possible assistance to astronauts that have an accident, distress, or emergency landing, but they do not contain specific obligations to protect humans in space at all times. Lacking international space traffic rules that give priority to the safety of astronauts and their spacecraft, and lacking a prompt surveillance and alert infrastructure, other space becomes an increasingly dangerous place for human presence. There are some fora where the topic of space traffic coordination is under discussion, like in the European Union and the United Nations. At national level, some rules are set. For example, in the US license requirements, the operator is ordered to mitigate the collision risk in general. In a particular manner, based on the strong commercial relationship between the US Space Agency and SpaceX, in 2021, NASA concluded an agreement with this private company to give priority right-of-way to all NASA space assets, such as International Space Station. This agreement could become a model to protect human spaceflight of any country. But with the dominance of few private firms in outer space, it becomes difficult to protect the manned spaceflight of all countries. Of course, there is the possibility for agreements of this sort if there is a strong commercial relationship between a foreign private company and a state, like the relationship between the US private company Tesla and China. In the cases where there are no strong commercial ties, the private companies may have a stronger bargaining power. The growing collision risk with operational spacecraft is one of the threats that the humans in outer space are facing. Another is the collision with space debris. The launching of satellites to lower orbits also generates space debris. Space debris result from items that detach during normal launch operation, rocket stages that separate after they propel a space object into space, satellites whose fuel is used up and can not any longer be maneuvered, those that suffer system ruptures and release fragments, those that suffer catastrophic explosions, or those that are intentionally destroyed. Over time, thousands of tons of space debris have accumulated in outer space. Before large constellations were deployed, researchers considered that from 5 to 10% of the satellites will suffer malfunction right after the deployment in outer space. This was later confirmed by the first batch of Starlink satellites. Thus, the deployment of large constellations of small satellites is also creating a large amount of space debris that will endanger manned space objects. With the concerns of a growing space debris population, researchers of space agencies responsible for collision warnings to protect their assets decided to establish a common forum. This group of experts published in 2002 a set of recommendations to mitigate the creation of space debris. These recommendations serve as a basis for the drafting of a set of guidelines of the United Nations Committee on Outer Space, COPUOS, that in 2007 were endorsed by a UN General Assembly resolution. Some of these recommendations are listed here. The last recommendation, to avoid intentional destruction, has been ignored, as demonstrated by the recent anti-satellite test of the Russian Federation. Fragments of this destroyed satellite endanger the International Space Station, forcing astronauts, including Russian cosmonauts, to take emergency measures, like closing hatches and taking shelter, following the risk assessment by the NASA Debris Office about an approaching debris cloud. For the mitigation of other kinds of generated debris, a growing number of states are adopting national legislation that obligate the application of the IADC mitigation guidelines for private companies that obtain a license. The question arises if the space tourist industry can develop given the present trend of populating the low Earth orbit with operational space objects and space debris. The start of the space tourism in Earth orbits coincides with the deployment of large constellations and at a time when states keep performing anti-satellite tests. Article 1 of the Outer Space Treaty assures that outer space shall be free for use by all states, while Article 6 stipulates that states shall bear international responsibility for national activities in outer space, and that the activities of non-governmental entities in outer space shall require authorization and continuous supervision. But neither the Outer Space Treaty nor other treaties impose an express obligation to protect humans in outer space. On the other hand, Article 9 of the Outer Space Treaty stipulates if a state party has reason to believe that an activity or experiment planned by it or its national in outer space will cause potential harmful interference with activities of other states, it shall undertake appropriate international consultations before proceeding with any such activity. The large amount of satellites launched in the past 2 years has been unprecedented. There are warnings of researchers that the low Earth orbital region is endangered. But at the same time, states deploying satellite constellations have not consulted the state parties to the Outer Space Treaty on this activity, not during the planning, not during the deployment. Another stipulation in this article states, a state party which has reason to believe that an activity planned by another state will cause potential harmful interference with activities in the use of outer space may request consultation concerning the activity. So far, no state has made use of this right granted by Article 9. No official request of consultation has been submitted to the states that are deploying large constellations. Of course, the plans on the purpose of the satellite constellations are publicly known through the international press, but the states should be requested to legitimize their activities, submitting how they will get under control the space traffic of the operational spacecraft and what are their concrete plans and actions to remove the emerging space debris to protect humans in outer space. Leaving the responsibility to private companies to avoid collisions or to apply debris mitigation measures is not enough supervision by the state, as it is provided in Article 6 of the Outer Space Treaty. So states have to start invoking the right of consultation based on Article 9. It becomes obvious that manned space objects should enjoy priority and that the operators of non-manned space objects should take all measures to avoid the orbital paths of such. The states need to agree, ideally by treaty, that all manned spacecraft should have the right of way and that the safety of persons in outer space is paramount. Several states are authorizing the launch of large numbers of satellites without any limit. Large numbers of licenses are granted without considering appropriate surveillance and infrastructure and conjunction assessment capabilities in proportion to the number of satellites licensed. The states need to limit the launch of space objects to the level of capabilities of a surveillance ground and spatial infrastructure that enable the satellite operators to timely receive information on conjunction alerts to reduce the collision risks. This only can happen with international cooperation because a larger number of tracking ground stations should be positioned all around the world. Another urgent measure that needs to be adopted is a ban of the anti-satellite tests. If states continue testing destructing capabilities, we will not have navigable low Earth orbits, and the door to other orbital altitudes may be closed for many decades. Just in the same way as we have only one Earth, we have only one low Earth orbital region that needs to be protected for human presence, not only for tourists that temporarily visit outer space, but for those who permanently live and work there, and for those who will venture to the moon and beyond. Thank you very much.